Good afternoon. I'm Leonard Baynes, Dean of the University of Houston Law Center. I want to welcome you to the CLE that's brought to you by the Big 12 Law School Deans. The CLE is entitled Navigating a New Era in College Sports. And as I mentioned, it's hosted by the Big 12 Law Deans. Last year was the first time that the Big 12 Law Deans assembled and collaborated on programming. We held a Dean's workshop at the University of Kansas Law School and a reception at the Stinson Law Firm in Kansas City, Missouri. We had thought about doing a CLE to accompany the workshop at that time, but it didn't happen. But it's happening now. Since then, we've been sharing opportunities to attend signature lectures among our collective alumni, hosted a joint reception at the Association of American Law Schools annual meeting, and hosted an important CLE on the law affecting what was going on in Minneapolis earlier this year. By the way of understanding the Big 12 law school deans is first I have to point out there's only 11 law schools in the Big 12 conference. And they are Arizona State University, Sandra Day O'Connor College of Law, led by Dean Stacy Leeds, who's going to be president-elect of the University of Tulsa, and she will serve as moderator of one of the panels today. Baylor University Law School under the direction of Dean Jeremy Counselor, BYU Law School under the direction of Dean David Moore, University of Arizona James E. Rogers College of Law under the direction of interim Dean Jason Creek, University of Cincinnati College of Law under the direction of Dean Haida Hamoudi, University of Colorado Law School led by Dean Lolita Buckner Innes, who will moderate one of today's panels. University of Kansas School of Law under Dean Stephen Mazza. Texas Tech University School of Law under leadership of Dean Jack Wade Nolan. University of Utah S.J. Quinney College of Law led by Dean Elizabeth Cronk Warner, who will be our third moderator today. And West Virginia College of Law under the direction of interim Dean Susan Brewer. On the eve of the NCAA Sweet 16's men's basketball games here in Houston, this CLE kicks off a week of events with the Big 12 Law School Deans, including a Big 12 Law School Deans workshop at UH Law Center, an all Big 12 alumni reception at the Houston offices of Norton Rose Fulbright. That's taking place on this Friday, 5:30 to 7:30. So if you're in one of the alums of one of the Big 12 law schools, please feel free to RSVP and join us in this great networking event where you can connect with other Big 12 law alumni and celebrate March Madness in Houston. Christina Van Arsdale will add the information about this reception in the chat. In today's CLE, entitled Navigating a New Era in College Sports, we'll hear from three perspectives: the General Counsel of Universities, who are navigating changes in NCAA rules and enforcement, attorneys who will speak to the changing role and status of college athletes, raising questions of antitrust and labor employment law issues, and finally, we'll hear from two academic experts with their perspectives on collegiate sports and evolving economic and societal norms. All three panels will have time set aside for audience questions. Please place your questions in the Q&A. We look forward to your participation. So let me introduce the moderator of the first panel. So the first panel is going to be a discussion by the General Counsel. It will be moderated by Dean Stacy Leeds. Dean Leeds is the Willard H. Pedrick Dean and Regents and Foundation Professor of Law at the Arizona State University Sandra Day O'Connor College of Law. As I mentioned earlier, she's also president-elect at the University of Tulsa. She's an experienced leader in law, higher education, economic development, and conflict resolutions, and she has quite considerable experience as a professor and administrator at major universities. She's a top national scholar, public intellectual, educator on indigenous law and policy topics. So without further ado, let me introduce Dean President-elect Stacy Leeds.
Thank you, Dean Baynes, and I'll ask the panelists to join me on camera as well while I'll make brief introductions. As Dean Baynes said, this is the panel of experts that serve in the role of University General Counsel. And I'd first like to introduce Donna Cornell. She serves as the Vice Chancellor for Legal Affairs and General Counsel for the University of Houston System, as well as Vice President for Legal Affairs and General Counsel for the University of Houston. She has both her undergrad and her law school degrees from the University of Texas at Austin. Next, I'd like to introduce Chris Holmes. Chris serves as a general counsel and chief legal officer and also corporate secretary at Baylor University. He received his bachelor's degree in political science from Baylor and his law degree at the University of Texas at Austin as well. And finally, help me join Robert Payne, our final panelist. Robert is deputy general counsel at the University of Utah, and he also received his law degree at that same institution. So thank you all for joining me here today. This certainly is a dynamic and amazing time in college athletics. And I'd like to start off with Donna, just asking you to help us recap the last 5 years of what's gone on in terms of changes. Tall order on a 70-minute CLE. But in particular, if you would help us with the development of the House antitrust case and walk us through that case and how it was resolved.
Sure. Happy to. Yes, it's been a wild time for all of us. We've all become experts in athletics, even if we didn't intend to do that at the early parts of our career. The House case was a class action case filed in 2020 on behalf of Arizona State University swimmer Grant House and Oregon women's basketball player Sedona Price, trying to take away the NCAA's power for restrictions on endorsements for college athletes and allow these athletes to share in television revenue, pay past athletes who were prevented from receiving what we call NIL payments. That's the name, image, and likeness. In order to understand that, you kind of have to go back a little ways and discuss the O'Bannon case. That was a lawsuit brought in 2014 by a UCLA basketball player, again, against the NCAA over the unpaid use of name, image, and likeness. He won at trial. The judgment was overturned on appeal to the Ninth Circuit. Following the O'Bannon case in 2019, the California passed the first NIL law, and 32 other states have eventually followed suit in that regard. And then in 2021, the Supreme Court acted on this NCAA versus the Alston case, and that's where they unanimously held that the NCAA restrictions on education-related benefits for college athletes violated antitrust laws. That was kind of the precursor and the notice to all of us what was coming. This case allowed schools for college athletes to provide enhanced academic support, like computers, internships, tutoring. There were previously very strict restrictions on what you could include in scholarships. But that case did not immediately remove the compensation limits. But Brett Kavanaugh, when he wrote his concurring opinion, was very clear to all of us who were paying attention that the antitrust laws should not, he basically said the antitrust laws should not be a cover for the exploitation of student athletes. That's pretty strong language, and we've really kind of understood what was coming. And he also referred to the other NCAA regulations that he thought raised serious questions under antitrust laws, and they would be struck down if challenged under same legal principles used by the lower courts in Alston. So then in July of 21, the NCAA announced new rules allowing NIL with limitations, and under that backdrop, the settlement was reached in the House litigation. It was approved by the court not until June of 25. And, we call it a settlement. For those of us who are dealing with it every day, it didn't really settle much. It created a 10-year injunction, replaced traditional scholarship limits, now allowing for the full cost of attendance, but imposed new specific roster limits that changed for the sports, provided a $2.8 billion pot of money for paying damages for missed NIL opportunities for athletes from 2016 to 2025, and then established a permanent revenue sharing model allowing schools to pay athletes directly. Of note to some public schools, there are different issues in that injunction and settlement, one being the mandatory arbitration provision, which is an issue, ongoing issue for many public schools in the entire country. And I think what's also interesting is that it's a 10-year injunction that basically is binding, you know, my grandchildren who are in middle school playing football. So it's kind of interesting that it's even going back that far, and what that means is still yet to be seen. The revenue sharing aspect is optional. Schools need to opt in to the settlement. Student athletes are automatically opted in, but can also opt out, and some have done so. The amount of revenue that a school may share, and again, these are all, I have to say all this with a little bit of, you know, hesitation, because we all know these caps. I'm sure many of you have read the caps are soft caps, I think some people call them, but we'll just pretend that it's a real cap, capped at 22% of the average P school's athletics NCAA reported gross revenue, with a 4% yearly escalator. And I think it's important for everybody here to recognize we're talking about gross revenue when we're talking about revenue share, not net revenue. Most athletics programs in the country do not make money for the schools, including the University of Houston. Both the Alston payments and the scholarships count against the cap. The current revenue share cap right now is $20.5 million. And this doesn't mean that pay for play is allowed at this point. We are still paying these students for their name, image, and likeness. We are not paying them to play. The way it works is we create written agreements with the student athletes. They take the form of an NIL licensing agreement. The school licenses the students' NIL in return for a payment for a certain amount of money. The amount of money should correlate with the value of that student's NIL. And so there are differences and variances. And none of this limits a student athlete from getting additional NIL from outside sources. And we'll talk a little bit later, I know in this program, about how all of this is enforced and what we're all doing with regard to this. And then you throw on top of all of that, I'm sure some of you have heard about all of the craziness with the transfer portal. Essentially, that is the marketplace for athletic services for our students. And so all of the models that we had pre-house for governance of intercollegiate athletics don't exist anymore. It is very interesting. The $0.8 billion portion of the House settlement has been stayed at this point because of a challenge by some former college athletes, female student athletes, alleging that the distribution formula violates Title IX. And that, again, is also something we're going to talk a little bit later about. Basically, they're arguing that they're not getting paid the same amount. And in fact, that is reality, because we have been making NIL payments and the women are not getting the same, the female athletes are not getting the same as what the male athletes are receiving.
Thanks for that. There's so much complexity just in the case itself, not to mention the practical ways that different departments are trying to apply and comply with the settlement. Robert, will you take it next and talk to us about how the settlement process is moving forward, and particularly touching on issues of enforcement?
Sure, happy to do that. Thanks for the introduction. I will say that, we all breathed a little sigh of relief when the House case settled. We thought it would provide a lot more certainty, and as Donna notes, we're still in the soup there. It's better, but there's still a lot of unknowns going forward. As Donna also mentioned, NIL or revenue share is a may, not a must. So we don't have to, and none of our D1 institutions have to provide it. We know that all the Power 5 institutions are going to do it, and the 300 plus other D1 institutions are going to have to make the decision whether to opt in or not. And it's my understanding that about 82% of them have decided that they're going to pay some portion of rev share. And so, now we sort of know who's going to do it. Then institutions have to decide, well, how much? How much of the $20.5 million am I going to pay? And we're all sort of going through that. And the question, of course, is how much do you have to pay to remain relevant in college athletics? And then, of course, there's the question of where does that money come from? There is certainly a fallacy in sort of the public dialogue that institutions and their athletics departments are awash with cash, right? And we're just looking for places to put this money in those poor student athletes. But as Donna noted, most institutions not only don't cover the costs, they come up with a deficit. In fact, if you look at some statistics on the SEC, they bring in about $131 million. And by the way, they bring in the most revenue against a $205 million cost to run all of their athletics programs. And then the question is, how do you come up with that extra $70 million? I'll be talking a little bit later about, some of the methods to handle that. So then we have to decide, how do you divide up that money? Which sports get the money? Which student athletes get the money? How much do they get? I think most institutions are following kind of the model that was set in the House case for the past damages settlement. So most institutions are paying their football student athletes around 75%, 15% to the men's basketball, maybe around 5% to women's basketball, and 5% over the other, 10 to 12 Olympic sports in the program. So we're struggling with that. We're struggling with, how to make sure that third-party NIL continues to happen, because this is the rev share is what we can do. But third-party NIL is also important, we all know. And so how can we facilitate that and help it happen in an ethical way, on reasonable business terms and for fair market value? And we're struggling with, how to recruit, how to keep our student athletes. They have options. As Donna noted, the transfer portal is a mess, and students are pretty much free to go wherever they want, whenever they want. So how do you attract them? How do you keep them? As Donna mentioned, we're working on our NIL agreements. What do they look like? Do we want them all to be roughly the same or similar? How much flexibility do we want? Do we want to include in them buyouts for student athletes? In other words, you've come to our institution, we're going to pay for your name, image, and likeness. And by the way, we own that now. If you're going to go to another institution, you're going to have to pay to essentially buy back your NIL. We're thinking about those things. We're thinking about limitations on transfer. And, we talk about, at least here at the University of Utah, do we want to limit our student athletes' ability? Because if we prevent them from going somewhere else, are they going to be happy here? And what good does that do us? So all really challenging issues. We want to stay out of trouble, as Donna mentions. Title IX prevents, requires some parity between men and women. And there are a lot of questions about how this rev share gets paid and is it equitable? And then these are all questions we have to answer internally, but we also are keenly aware of what's going on externally. So this whole system is sort of designed, to try and put us all on a level playing field. And in order to do that, you have to have an enforcement mechanism that works to make sure that everybody's playing by the rules. And right now we're struggling with that. The College Sports Commission is designated as the entity that's supposed to be doing that, but it requires buy-in from all the institutions to do it. So we We're, passing around drafts of the participant agreement that's going to bind us to the CHC or CSC rules. And we've had some trouble getting that in place. So we're working with that, but we really need it. We really need the enforcement authority and to start. Anecdotally, I understand that people believe there's about $500 million in third-party NIL that has been given, but only around $127 million has been reported thus far to the College Sports Commission. So, every one of those deals over $600 is supposed to be reported and vetted by the College Sports Commission and approved. And if students do it inappropriately, then there's supposed to be enforcement, and that's not happening. So that's a struggle. And then, of course, we're all, I'd say, cautiously optimistic. Maybe that's a little too strong, that the federal government will actually do something, that Congress will step in and provide some guardrails to help us in this. And I believe Chris is going to be talking a little bit about that later. Let's see. And then I think Donna kind of touched on this, and that is it's a $20.5 million cap, but institutions are creative. Everybody's pushing the envelope. If I tell my multimedia rights partner that it's okay, the $6 million that you owe me, why don't you just keep that and use that for third-party student athlete NIL? Are those institutional dollars? I would have had them in my pocket yesterday, and I've now given them up to you. And so I think originally people would have thought, yes, that's part of your cap. And now the direction it's going is, well, okay, we won't call it part of the cap, but you just can't get any of that money back from your multimedia rights partner. So it's an ever-changing landscape, and these are some of the challenges that we're dealing with. So,
as a single follow-up question to you, for our audience, can you just briefly describe what the jurisdictional contours of the CSC are versus the NCAA? You've got two competing enforcement bodies. So can you break both of those down in an elementary way?
Yeah, I'll try and do that. So the NCAA, of course, has always their job. We're a voluntary. The NCAA will tell you whenever you ask them to do something, well, we're just you. You're all the schools that make up the NCAA. So you make the rules, we follow the rules. It's a voluntary organization. Historically, the NCAA has enforced all of the rules that we have as a body put in place to govern college athletics, including the things that have resulted in findings of antitrust violations. Going forward, my understanding is that the NCAA will continue to enforce all of those rules, but that now we have the College Sports Commission that is separate from the NCAA, and its job is to enforce the rules surrounding revenue share and NIL. So making sure that all the institutions are not, we'll report all of our information to the College Sports Commission. They will make sure that we're not exceeding our caps. They'll enforce things when people do exceed the caps. And they'll be in the position to monitor all of the third-party NIL to make sure that they are legitimate business deals with student athletes and that there's a true fair market value. They work with Deloitte and Touche to assess those transactions. So that's my understanding of the kind of the division of responsibility between the two organizations.
All right. And Chris, as we come to you, hearing Robert and Donna, the single word that is the throughput on both of their descriptions is just this struggle to try to move forward to sort this all out. It raises more issues than we have resolution for. So what's happening in the field next? What are the next lawsuits? What are the next conflicts? How are those going to be sorted out?
Oh, thank you very much. Yeah, so we are seeing a significant amount of litigation continue even after the House case. And the types of cases that we're seeing really are kind of falling into four general areas. The first relates to antitrust challenges to the athlete compensation rules, kind of those issues in and around the House case, and I'll cover those in a moment. We're also seeing eligibility disputes The next area is NIL and revenue share contract enforcement issues. And then finally, perhaps most significantly, is the looming question of whether or not student athletes are employees of the institutions. Donna did a great job of going through House. Let me talk real quick about some of the litigation we've seen in and around House. The one case is the Chalmers case, and that involved 16 former Division I student athletes who had participated in intercollegiate athletics 4 years prior to the filing of the House case. And so these plaintiffs came in. This was filed in the Southern District of New York against the NCAA and major conferences, alleging violations of antitrust similar to that was brought in House. The district court dismissed that case with prejudice in April of 2025, in part based on statute of limitations issues. The Second Circuit affirmed that dismissal in December of 2025. Another case that is in this sphere is the Fontenot case. And Fontenot versus NCAA shows how the House settlement, the individuals that opted out of that class action case and how they're pursuing their claims outside of House. And that case is currently brought by 309 plaintiffs. Each of them opted out of the House class action settlement. The parties have agreed in that case to try the case in stages, beginning with an initial group of 45 plaintiffs that were selected earlier this year. That group is now in discovery. And so the next area that we're seeing litigation in relates to eligibility. And I've certainly seen over the last several months lots of news reports on these types of cases. And these cases primarily attack various aspects of the NCAA, the organizations within the NCAA, their limitation on how long a student can play. And typically, with recognizing there's some exceptions, that's called a 4 seasons over 5 years rule. And the litigation we're seeing is whether or not play at a junior college or prior play at a Division II school should count in those calculations. And similarly, we've seen some litigation over redshirt rules and how those redshirt rules are applied. Diego Pavia, a quarterback at Vanderbilt, brought probably the lead case in this category. Pavia had played 2 seasons at a junior college and 3 more at Division I schools, exhausting his eligibility. He argued that counting his junior college seasons against his NCAA eligibility clock was an unreasonable restraint on the labor market for college athletes. The district court granted him a preliminary injunction in December of 2024, allowing him to play the 2025 season. In response, and working to kind of make it equal across the country, the NCAA then issued a blanket waiver for all similarly situated former junior college students, which ultimately mooted the appeal of that case that was then at the Sixth Circuit. After remand, Pavia amended complaint expanded to include 27 additional junior college plaintiffs seeking a permanent injunction for the 2026-2027 season. And, Pavia's case definitely opened this process, and we're now seeing that there are more than a dozen junior college eligibility cases in various courts. Another eligibility case is for Quarian versus NCAA, where a Division II student athlete preliminary injunction was reversed by the Seventh Circuit for insufficient evidence of anti-competitive effects. And another case, Patterson versus NCAA, where the federal district court in that case denied a preliminary injunction challenging the 4 seasons over 5 years rule, notably rejecting the idea that injunctions limited to individual plaintiffs are adequately narrow because the ripple effects that those injunctions will have on other student athletes, but also the litigation from similarly situated players trying to get another season of eligibility. So what makes these federal cases interesting is they draw our attention to a divergence that is developing between outcomes that we're seeing in federal cases versus outcomes we're seeing in state courts. Federal courts have increasingly denied preliminary injunctions in eligibility cases, while state courts, often located in the same communities where the student athlete is wishing to continue playing, have been more willing to grant that immediate relief. The Johnson case illustrates this type of scenario. Donovan Puff Johnson, an Ohio State basketball player who played for 3 seasons at North Carolina and 2 at Penn State, was denied a hardship waiver after injuries during the 2024-2025 season. He first sued in federal court in November 2025 for antitrust. The federal court denied his preliminary injunction and motion for reconsideration, and Johnson then voluntarily dismissed the federal action and refiled in Ohio State Court in January 2026. That state court granted a TRO the very next day, making him immediately eligible. The NCAA tried to remove the case back to federal court, but was unsuccessful. This case is awaiting a decision on Johnson's motion for a preliminary injunction. So the third area of lawsuits that we're seeing right now relates to what Robert was talking about with the contracts that institutions are developing related to revenue share with the students attending their institutions. These cases raise novel questions about the enforceability of these contracts and what constitutes tampering in the new landscape. In June 2025, the University of Wisconsin and its NIL collective sued the University of Miami, alleging that Miami induced a student athlete to break a 2-year NIL contract and a transfer. According to the complaint, Miami sent a coach and a prominent alumnus to the athlete's family home in Florida and convinced him to leave Wisconsin. When Wisconsin refused to enter his name in the portal, the athlete disenrolled from Wisconsin and later enrolled at Miami, competing for Miami in the 2025-2026 season. The lawsuit brings claims for tortious interference and seeks a declaratory judgment that Miami's conduct constituted tampering. Miami has moved to dismiss on personal jurisdiction grounds, arguing that the contacts alleged to have occurred in Florida. The court has granted Wisconsin's request for a jurisdictional discovery, and that case is ongoing. And then I think the most recent development we've had in this area, I saw the news just within the last week or two, is the 18 Nebraska football players who have filed an arbitration proceeding seeking to overturn a recent decision by the Collegiate Sports Commission, CSC. That's the enforcement mechanism that Robert was talking about. While Nebraska as an institution is limited under the House case to $20.5 million in revenue share under the House case, Nebraska has asked its multimedia rights partner to decrease the amount of money the company is paying to the institution, and in exchange, pay that money to Nebraska student athletes of more than $8 million for NIL activities. And the multimedia rights partner, importantly, doesn't really have the specific items identified that those students, but they understand that they'll be able to identify it by the end of the school year, by the end of June. The outcome of that arbitration proceeding is going to be very important to watch. This is the highest profile arbitration that we've seen under the new CSC enforcement mechanism. And the final area is employment. And I know that we're going to have a couple of panelists after us that are going to discuss this in more detail. But the most consequential question is really probably coming out of Johnson versus NCAA. That's filed in the Eastern District of Pennsylvania, and it was filed in 2019. It's by former Division I student athletes who allege that the NCAA and member schools jointly employ student athletes and owe them minimum wages under the FLSA. In July of 2024, the Third Circuit held that the athletes are not categorically barred from FLSA claims and articulated an economic realities test. looking at whether athletes perform services primarily for the institution's benefit and under its control in exchange for compensation or in-kind benefits. That case is currently in the district court with motions to dismiss pending. And even on the executive side, President Trump signed an order in July 2025 titled Saving College Sports, directing the Secretary of Labor and the NLRB to clarify athletes' employment status. This landscape with respect to employment remains extremely fluid. What should be clear from all of this is with each of these areas, we've got a lot happening. And when we take a look at the fact that we're in 4 different areas with 4 different types of cases, it really does provide a pretty good indication of just how fluid our situation is.
Thank you for that. And I think that at least 2 of the 3 of you have already mentioned the issues that all of this raises around Title IX and opportunities for women student athletes. Let's go back to you, Donna, and talk through this issue.
Sure. So, we thought we really understood Title IX. It says you don't discriminate based on sex. That's like not that complicated. And we kind of have understood that in the athletics context, and we have provided equitable opportunities for our student athletes. Same things have to be given, the same kind of scholarships, how a school, they're meeting their athletic interests and abilities. We've got to have pretty much equity there. And then, it's kind of funny because Chris just was talking about the Trump's order. And then we had in January of 25, we had the Biden administration issuing guidance about Title IX and NIL, basically saying we could be, if we're paying our student athletes through NIL deals, could violate Title IX if they're not distributed equitably. Wow. What does that mean? Obviously, none of us have been doing that. And then, of course, on February 12th, we had the Trump administration rescinded all that guidance. So here it is. Take it away. The distribution formula approved by the court in-house for the $2.8 billion settlement is calculated using the NCAA reported gross revenues in the following categories: ticket sales, guarantees, media rights, NCAA and conference distributions, royalties, licensing, advertisement, scholarships, and bowl revenues. Many schools use the same distribution formula for rev share since the courts already approved this model for NIL back pay. That's probably the safest way to go, but this revenue share model means that, as we've said, a large share goes to football, a lesser amount to men's basketball, even lesser amount to women's basketball, with a tiny bit left for other sports. The only revenue generating sports for most schools are football and men's basketball, which explains this discrepancy. And it's not uncommon for schools to distribute unevenly for student athletes. The other model would be to do it similar to how we used to do things and make it more equitable. While it might be compliant with Title IX, it would disadvantage revenue generating sports, could result in other legal challenges. Not could, it absolutely would result in other legal challenges. We know everybody likes to litigate everything around here. But Title IX is an area that to me is incredibly unsettled. We don't know what it's going to ultimately mean. It ties back to what Chris was talking about with regard to whether or not these student athletes are employees or not. I mean, I know I've been singing this song for the last couple of years, because if you look at the 21-point test the IRS uses for what's an employee and what's not, you just read the test and you'll see where it takes you. But Title IX is an issue that's still outstanding for us.
Now, we've heard about both of the last two presidential administrations having guidance and executive orders on this. Chris, I want to go back to you and talk about a lot of people pushing and positioning for Congress to weigh in here. What do you see on the horizon there? What do you think is the most likely?
Well, I was about to report that I'm tracking 6 different bills, but Senator Tuberville announced one yesterday, so my numbers changed. But I think what I'd like to do is to kind of go through and explain really what the issues are that we're seeing Congress debating, recognizing, again, we've got lots of different bills out there, but rather than try to go through each bill specifically, let me kind of focus in on the issues and kind of where the different parties are tending to line up. So one of the bills that has had the most movement is the House's SCORE Act, and this has support of the leaders in the House Energy and Commerce, Education and Workforce, and the Judiciary Committee. Senator Cranz, who is chair of the Senate's Commerce Committee, also has been working with colleagues to get a bipartisan bill out through the Senate that he's hoping to introduce in the Senate. But realistically, let me kind of cover the issues that these bills are addressing. The first one is employment. The SCORE Act includes a provision that would prohibit student athletes from being considered employees. Representative Trahan has introduced an act called the CARA Act, which seeks to explore how student athletes could benefit from collective bargaining without necessarily classifying them as employees. So it seems that we're seeing really the discussion in Congress on this issue is it really to these student athletes' interest to designate them as employees, or is there a way to keep them from being employees, but perhaps even with the Democratic Party, is there a way to actually tuck in a non-employee context collective bargaining? I think the second area is state preemption. So in the area of NIL, we've had different states that have passed different laws that would seem to provide specific benefits to students, to their institutions for students to stay in those areas. I won't name the state, but one state said, hey, we're going to pass a law that if you're a high school student, you cannot get NIL or revenue from a college or university unless you go to our flagship. And if you go to our flagship, then you can make NIL on only our flagship. But if you go to our flagship and make NIL, then we will permit you to receive that. So the SCORE Act would prohibit state laws that govern or regulate student athlete compensation, benefits, or employment. The Democratic Senators Cantwell, Booker, and Blumenthal have proposed a more limited protection with several carve-outs for specific state laws such as consumer protection or state laws regulating agents. I'll come back and talk about agents in a moment. But the third area is limited antitrust protection. So we've talked about how different rules that the NCAA has have been attacked for antitrust. And so I think what Congress is looking at is, hey, how do we allow associations or conferences to have uniformity, a level playing field among their institutions without those rules that help protect that level playing field, without those rules actually being attacked for antitrust. Interestingly, another antitrust issue that you may see in the news over the last couple of months has been whether or not the institutions should be permitted to pool together and negotiate with their media partners as a single entity. This would be an amendment to the Sports Broadcasters Act. And There's been a lot of discussion recently about whether or not that would allow more finances into the institutions that could then be used for specific purposes that Congress wishes to have those used for. But at the same time, there's also been some organizations that have said that's not going to generate as much revenue as is thought. The most recent example of a bill seeking to amend the SBA is the Bipartisan College Sports Competitiveness Act that was filed within the last couple of weeks by Senators Cantwell out of Washington and Schmidt out of Missouri. Number 4 is a real cap. And we've been talking about how the House settlement adopted its approach to up to 22% of the A5's annual athletic revenue. And the SCORE Act tends to follow that type of model. The 5th area is governance. Many of the bills seek to modify the governance of intercollegiate athletics. Proposals from Republicans tend to remain more deferential to existing structures and working to reform the NCAA within the NCAA, while the CARA Act that I mentioned earlier would propose a federal commission to stabilize college sports. So the Democrats at least have indicated more federal oversight, a federal committee, a federal commission might be necessary. The final area that I'd like to talk about is agents. And I think both political parties seem to recognize that more intense regulation of sports agents is appropriate. The SCORE Act would restrict agents, this is an example, to commissions of no more than 5% commission, and would encourage agent registration. So I would expect that seems to be a fairly uniform part of both parties' bills that we're seeing. And then finally, we got President Trump involved as well. In a meeting on March 6th, President Trump said that an executive order would be coming out shortly addressing intercollegiate athletics. It was an interesting quote. I'm just going to read a portion of it because it kind of ties into our overall theme. I'm going to put my referring to his executive order, and we're going to put it forward, and we're going to get sued. We're going to see how it plays, okay, but I'll have an executive order which will solve every problem in this room, every conceivable problem within 1 week, and we'll put it forward. We will get sued. That's the only thing I know for sure. And so I think on that note, I will say I think President Trump is correct. Based on our discussion this morning, we do expect, or this afternoon, we do expect that the lawsuits will continue.
Great, thanks for that. As we're starting to push into the final 1/3 of our time, I'll remind our audience that if you want to put any of your questions into the chat, provided we have time, we'll try to pick some of those up at the end. But now I want to shift gears back to Robert. As universities are trying to figure out how they're going to fund this, people are getting very creative, and all eyes have been on the news coming out of Utah, and this question of what role private equity might play in this landscape. So would you start us off by just talking to us about the context and also describing the Utah decision to enter into this space?
Sure, happy to do it. I guess I'm going to back up just a little bit and answer the question, why do we do it? Why do we care?
Yeah.
And I think it's important to recognize, this is the University of Utah's perspective, but I don't think it's unique, that our athletics department, although, a fairly small economic unit within the institution, has an outsized role in terms of the importance to the institution. Our former athletics director used to say to me all the time that the athletics is the front porch of the institution, and I think it's absolutely correct. And so it's the place that we are introduced to students and greet them and recruit them and encourage them to come. It's the place where we create loyalty with our alumni and our donors, and it has a real meaningful effect. And just as a couple examples, when Alabama had its tremendous run in football and was winning year after year, during that time period between 2006 and 2020, their undergraduate enrollment increased 49%. And that's the lifeblood of an academic institution. But not only that, they significantly increased the out-of-state students who were coming to Alabama. And of course, those students pay about 3 times what the state schools or state students bring in. As another example, when Boise won the Fiesta Bowl, prior to that time, their student enrollment was 85% Idaho and 15% out of state. And over the following years, they flipped that to 48% Idaho and 52% out of state students. So it really, what our athletics departments are doing is critically important. And so from the University of Utah's perspective, we need to keep that program strong and successful going forward. And the reality is none of us know what the future holds. I mean, I think what everybody has heard today is it's a mess. It's far from settled, and it is. I mean, we fully expect more movement among the conferences. There are talks about, super leagues and the whole business. And if institutions are not remaining relevant and on the cutting edge, it's likely that many will be left behind. So we recognize that. So we need to be creative in this space. As we talked about a little bit earlier, institutions are not covering the costs. Institutions are going into debt. I think I heard Ohio was $40 million in debt. And so we have to find ways to make up that difference. And I think what the public doesn't recognize is that football is the economic engine of our institutions, and it brings in the revenue and it supports all of those other sports. So if we want to keep those other sports strong, we have to find ways to come up with the shortfall, because if we look at a cost-cutting method to covering the 20.5 plus 4% annually, that cost, it's going to mean losing sports, and that has huge implications. There are expectations by conferences that you maintain a certain number of Olympic sports. So it has real ramifications for institutions. So how do we do it? I think at our institution, we looked really carefully at the different options. One, as our president said, the first option, which is to do nothing, is not an option, because it will lead to really the demise of our athletic program. But it was important to our president to not burden the rest of the institution with the significant costs of the athletics program. So some institutions are going to look at raising student fees to cover these costs. Some have done that significantly. And in a time when enrollment in higher ed institutions is decreasing, and it's becoming harder and harder to recruit students, we think that's not a viable solution. Other institutions have looked at, looking at other units within the institution to fund this economic model, whether it's, funds from your bookstore or other auxiliary services. And so it's important that our president is really committed not to tapping the rest of the institution, keeping the whole institution strong as we move forward. Another model, of course, is to go out and borrow money. There's a lot, you just borrow what you need to meet your needs on a going forward basis. But of course, that just kicks the can down the road. At some point in time, you're going to have to pay for it, and those costs are ever increasing, and that didn't seem like a good solution. So we decided that private equity has been sniffing around the edges for years, and their model is they want to find an industry that is, from their perspective, underperforming in terms of revenue, and they want to come in and they want to partner and they want to boost the revenue and they want to profit from it. And there are obviously risks with that. Aligning their interests and the higher ed institution's interests is not always easy. And it's my experience, they don't necessarily understand the complexity and of all that we do as higher ed institutions. So there is definitely an education component on both sides of the equation. I feel fortunate at the University of Utah to have the president that we do at this point in time because he was actually the dean of our business school before. He understands creation of businesses. He understands private equity. He's surrounded people in his administration who understand it. And we have people on our board of directors who are very savvy business people. So my undergraduate degree was theater arts, and it's slightly different from what they're looking at in terms of the business model here. So I feel good about sort of relying upon them to do the business analysis, and then of course our office is helping them to get there from a business perspective. So I think we have to balance those risks. We have decided that going the direction of private equity is the right thing to do, and it's the right time to do it from our perspective. We think there are risks with being one of the, well, perhaps the first to do it, and that and I traditionally don't like being at the tip of the spear, but oh well, here we are. But there are advantages to it, right? Because one of the things that's critical to the university is that we get the right partner in terms of a equity partner. It's not enough simply to lock arms with somebody whose whole motivation is revenue, right? Because they'll get there at any way they can. You need a partner who, at a minimum, understands the sports model, and we think we found that partner in Otro Capital. They have been in the professional sports space, and they understand the ways to enhance a business's brand. They understand how to make money off of sponsorships and to bring in revenues through tickets and to strike the right balance between keeping fan engagement and enhancing the fan experience while charging what fair value is for tickets. This is what we're told. I believe this to be true. We will see. And so that's the direction that we're heading. Let's see. And I think it's important to note that if you get the right partner, I mean, there really are there are common interests between the institution and the equity partner, right? If we don't succeed as an institution, if we don't grow our fan base, if we don't grow the businesses who support our institution, then they don't profit. So it's in our interest to find a partner who can actually do that, who is in a space that we are not. I mean, we're about education and we're about healthcare and we're about, taking care of students, but we're not really good, from my perspective, about effectively raising money. We're very decentralized. We're not tremendously disciplined. And we think that bringing in a partner is going to help force us to be a little more disciplined in how we do this. And that's probably a good thing. So, all right. In structuring the deal, it's, there are very important things to keep in mind. One is they're really good at raising money. They're really good at that aspect. They may have a lot of advice and assistance in terms of helping us understand how we can improve our athletics programs, but that is what we do. And so it's very important that we set up a structure where the institution maintains all the decisions about coaching hires and fires and what student athletes we bring in, and every aspect of whether we build buildings, whether, all of that has to be preserved by the institution. And in addition to that, we must maintain our control over our brand and our reputation. And so in we'll create a private entity, a for-profit entity that will own the majority share in, so that we can actually veto decisions that are not good for the institution and work collectively. So that's the structure that we're working to put in place. And then I think you had asked one question about, what about the exit? What happens, right? Private equity They're not in it for the long run. They're in it for 5, 7, maybe, outside 10 years. And then what happens when they've decided, okay, we're satisfied, we're packing up our bags and we're going away. We're going to preserve our ability to have a lot of say over what happens, about whether, if somebody else comes in and takes over their position. And that might be the right thing to do. We might be able to lock arms with another organization that has great insight and expertise. But we may also make the decision that, we've really learned how to do this, and we're going to bring it in-house and do it ourselves. So I think that's a very strong possibility of where we'll be in 7 years or so.
I think everybody can see the potential upside on game day experience and on the operational front. I think all eyes are watching how you actually structure this deal and as you described, what the longevity of it looks like. So thank you for that.
Yeah, sure.
So on this webinar, we also have a number of law students that are making their way through their career. And some of the 11 schools that have law schools within the Big 12 have sports law or sports law and business programs. But each of you have very different backgrounds. And so I want to ask all three of you if you'll just briefly talk about your pathway to getting into a place where you can work on these topics, and any advice that you have for our current law students that are making their career journey. So Donna, you want to start us off?
I'm happy to start. So I came up, before I went to law school, I worked in the legislature and was very interested in the creation of laws. That kind of pushed me into law school. And then, I got out at the height of the oil bust. And so I had to figure out what I was going to do. And I went into litigation. I actually worked for the Attorney General's office. And that was back in the day. They kind of threw you a file and you just go try it and you learn on the seat of your pants. And I ended up staying in litigation for 16 years. And that really is and ended up representing universities throughout Texas. And that's what kind of pushed me into representing different universities. I met the then president at the University of Houston in a case that we tried, and he asked me to move, and I said no. And he asked me again, and I said no. And then I obviously said yes, and I've been here, 24 years, which is an incredibly long time and hard for me to even believe. The trajectory of litigation to this, I explained to my friends that are in litigation. You're going into trial, your things are being thrown at you. You never know what to expect. Being a general counsel for a university, especially in 2026, is like being in trial all the time. Mm-hmm. I never know what's going to happen. And with this administration, things change. And both the state and the federal, if you're a public institution, things can change for you on a day, every day. And they sometimes do. And you just have to be prepared for that. I think it's a great career. Sports law is an incredibly fascinating aspect of what we do. It's not all of it. It is more and more of it for all of us, I think, than we ever really would have anticipated. That's not a bad thing necessarily, but it does bring in all the other aspects. You've heard us talk about antitrust. You've heard us talk about employment. Those are all things that we deal with on a regular basis. And so I think it all ties together.
Great. Chris?
Sure. I had a litigation background for the first 10 years with a firm in Dallas, and then joined another private institution as their general counsel, and then came to Baylor about 24 years ago. So I echo what Donna said in that we are seeing two things and within higher ed and general counsel's offices. Number one, our offices are actually growing. the amount of law that is impacting our institution continues to grow. The legal complexity for our organizations continues to grow. I think that the coming out of that also is I was at the National Association of College and University Attorneys meeting earlier this month and spoke on a panel similar to this on this topic, and asked the general counsels that were in that room how many of their offices are spending more time and having to put more legal resources toward athletics. And everyone raised their hand. It's just becoming more and more of something that's needing constant attention. And our client, the athletic department, is actually having more and more legal issues. So,
Robert?
Yeah, well, there's a common theme here. So I was in private practice for 10 years. I was 7 years with a large Utah firm, and then 3 years with Snell and Wilmer, a regional firm out of Arizona. And I was a commercial litigator. I had decided to become a plumber. And I got a call from somebody at the University of Utah saying, maybe plumbing isn't the right thing for you. How about coming up and working for us? And thank God that happened. I will just say, if you're thinking about it, it's the best legal job of any that I have seen. And you can have a litigation background, but you can also have a transactional background, and our office is pretty much split maybe 50-50 between the two. I think personally, if somebody who comes out of a litigation background has a richer experience, I describe my practice as being in a room full of balloons, and my job is I'm bouncing the balloons up. I'm keeping anyone from hitting the ground as long as I can, and periodically I get to pop one and sort of get it out of the room. And it's fun. It's a lot of work. It can be stressful, but it's a lot of fun. So I highly recommend going there. And I've now been doing it for 25 years. So
I appreciate you all three sharing part of your journey with us. I want to ask one more question, and this is more just for all three of you to chime in as you want. But back to the question that Chris talked about, whether student athletes are appropriately classified at some point as employees. Still a question that's very much alive, but in a slippery slope type argument, for all of the other students across all of our campuses that work in areas that are important to the reputation of the school, that involve the hours that student athletes engage in. And from a law dean's perspective, the first two of our student groups and quasi law school institutions would be people who work on the law reviews, or our students that compete in moot court competitions, volumes and volumes of work, who also have scholarships attached to it by the virtue of the positions that they're in. What are the other areas across your campus that you see potential issues bleeding over from what's happening in college athletics that have you thinking through the future? So any of the three of you.
I don't really see the same risk for our other students that, clearly they work hard. I don't see the same risk that we have. I mean, we really need some federal legislation to fix this once and for all. I don't think it will impact those other areas. And it's really, the argument in athletics is really the revenue that is being brought in and the rules that were in place by the NCAA that prohibited students from getting anything other than a scholarship as defined by the NCAA and its very rigid rules. I don't see those same limitations. The employment of all of the different risks that are out there, the employment issue is the one that has the greatest potential. It could be a huge class action. Are they exempt employees? Have we denied them their benefits, their retirement? their what have you, their salaries, are they non-exempt, and did we pay them the right overtime? I mean, I don't know.
Absolutely. Either the other two?
Well, I think slightly different issue on the employment is, and I agree with Donna in that I really do think we need some clarity under the FLSA. On the employment issue, have a very real concern that what could work at a Power Four institution for football.
Mm-hmm.
If we run through that same analysis, there's a concern that at some point that economic driver that starts to fall off, and particularly if we think about think about that test of did the coach require the student athlete to be at practice at 8 a.m.
Mm-hmm.
Well, that may make sense at a P4 institution, but does it make sense at a junior college? Does it make sense at a D1 school that is not in a major conference that is having significant issues merely getting their team to where they're supposed to play that weekend? Not in football, maybe in football, but in other sports. And so what may be seem like makes a lot of sense for a football at a P4 institution, I think the concern is whether or not that will continue to apply that same rationale, and the unforeseen consequences or foreseeable consequences of adopting that rule in this context for all the other different colleges and universities that are truly offering athletics as purely a student experience. I think that's where we're kind of needing. That's where we're really going to need help.
Robert, something that you mentioned was, very quickly in your conversation, the idea of these super leagues, building off of what Chris just said. And, last week in the news, there was this conversation about potentially splitting off some of the NCAA Division I. Got pretty strong rebuke from the smaller schools, not wanting to lose their independence, not wanting to be, classified as a farm league for training up people who would transfer out. Can you talk a little bit about where you see ideas like that going? Are there legs in that suggestion?
Yeah, hard to know. I think that's been discussed for a long time, and it's particularly at the SEC and the Big Ten. Whether it made sense actually for them to just sort of carve themselves off and become their own system for competition. It's hard for me to know where I mean, I think all the Power Five institutions would want to be part of that if it happened. I'm sure that everybody, and obviously that can't happen. I don't know that I have a good sense for whether that's going to have legs, and but what I am confident about is that at least the shifting around among conferences and what the conference makeup is and what it looks like is certainly going to change, because I think we have now burdens of what the professional sports have, and none of the benefits, none of the controls that are in place. A professional student athlete doesn't have the whim to just move, where they want in between. And I just think we're going to look much more like a professional sport experience. And that may be driving us toward a super league model. I don't know if my colleagues have other thoughts on that, but.
If not, there's kind of a theme in the Q&A. We've got about 4 minutes left. And a lot of the questions seem to get at the calculation of fair market value that the university conducts, trying to make the determination of a student's worth in name, image, and likeness. Could either one of you talk just briefly about how universities are conducting those sort of inquiries on their own campuses? We mentioned the partnership with one of the big accounting firms, but what are the typical ways that universities at different levels are going about this?
That's an interesting question. I mean, when we're talking about so when we're talking about revenue share, we don't have to do a market analysis. We have pretty much unfettered discretion. There may be, maybe Title IX has something to say about it, but we have broad discretion on how we can decide to share our revenue. It is supposed to be based on name, image, and likeness value, but I doubt there's going to be much enforcement there. On the other hand, third-party NIL is going to be governed by the CSC, and Deloitte and Touche, and they're going to do a market analysis. And how that happens, I don't know. I know, fortunately, this is not a legal issue at the institution, so I don't have to be in the room to understand the black box where the athletics department decides how much they're going to give to any particular student athlete. I'm not sure how they do that. I don't know if anybody else has a good sense for that.
I think it is helpful to kind of understand that there's really two types of payments that are occurring. There's the institutional revenue share, which that's really the athletic department that's overseeing that, and then there's the sometimes we refer to it as the true NIL. It's the NIL that's coming from a third party. Where they're actually wanting to contract with that student athlete for their NIL. And in those situations, I think the institution's main responsibility is just to make sure that those are being reported to CSC to go through the CSC's process.
Okay. And I'll note, as we have just our final minute to wrap up, there's several questions in the queue around this ongoing conversation about employment. And I'll just mention that our next panel will explore the employee-employer relationships with much great detail. So with that, I just want to thank the three of you for being here with us today and for all the work you're doing at your home institutions. And at this point, I will transition us back to Dean Baynes to pick up the introductions for the next panel. Thank you so much.
Thank you.
Thank you.
Can everyone see me and hear me? Yes. Okay. So I'd like to introduce the next moderator, my colleague, Dean Buckner Innes from University of Colorado School of Law. So the second panel is going to be attorneys going to be looking at these issues from the athlete's perspective. Lolita Buckner Innes is the Dean and Provost Professor of Law, University of Colorado Law School. She's a distinguished academic leader, scholar, and public servant. In addition to her other titles, she's an affiliate of the Center for African and African American Studies. As Dean, she's overseen one of the largest clinical education gifts ever received by the institution. She's a widely respected legal scholar with a distinguished national and international reputation, and she's an elected member of the American Law Institute and a prolific author of many articles, essays, and acclaimed legal history book. Let's welcome Dean Buckner Innes, who will introduce our panel.
Thank you so much, Dean Baynes. It is a tremendous honor to be here. And as Dean Leeds mentioned a few moments ago, our panel is going to pick up actually where the previous panel left off. And I am so pleased to be here. I have two distinguished panelists who are going to be participating in our conversation today. The first one is attorney Brian Michael Cooper. He is of counsel with Greenberg Trarg. He is also an adjunct professor at the University of Houston Law Center. He has a distinguished career in many sports industry matters. He is the former president of the Houston Roughnecks, the XFL. He's a former president of the RGV Vipers and also former president and COO of American Flag Football League. Next, we also have Professor Mark Edelman, who is professor at the Zachlin School of Business at Baruch College, CUNY. Professor Edelman is the director of sports ethics, which I think will, of course, figure prominently here. He's also the Robert Zicklin Center for Corporate Integrity director. He's an adjunct professor in addition at Fordham University School of Law. I think, of course, as fascinating as the previous conversation was, we could tell as if the conversation was tapering off. What's often highlighted and not necessarily spoken of enough is the role of the athlete when we're talking about these matters. And I know at Colorado Law, we started to do a lot, for example, around NIL. So I want to start with a question for our panelists. That sort of, I think, frames the conversation today. And that is, when we're talking about the role of college athletes, and especially the incredibly changing role of athletes, what exactly is this conversation about? I mean, is this about rights of the athletes? Is this about antitrust? Is this about employment or labor law? And I think that particular latter part is really salient for a lot of the folks as I look, for example, at some of the comments that have come into the earlier panel. So I wonder, Attorney Cooper and Professor Edelman, by turn, starting with Attorney Cooper, if you could address that question for us.
Yeah, thank you, Dean Ennis, and thank you for having us here today. I think it's all three. I think that it really is a question of rights. You talked about the right to publicity, right to the value of NIL of the athlete, but it also delves into antitrust as well. I tell my students, that sports is, and antitrust go together like peanut butter and jelly, and they generally do. I became an antitrust lawyer because I was a sports lawyer, and so that's kind of the mechanism in which those rights are kind of outlined and demonstrated to how you can seek recourse for those. And I think ultimately, as our panel before us talked about, the GCs talked about as well. I mean, you now have the specter of labor law and trying to come to a determination on how you manage what I call an economic evolution of college sports, where revenue has come into play. One of the cases that I love to talk about, that I always think, and kind of harking back, and I just kind of do a little bit of going in the Wayback Machine, but it's a case I always bring up. And I think when we're talking about the context of NIL, is the Board of Regents case from 1984. The Board of Regents of the Universities of Oklahoma and Georgia versus the NCAA, or vice versa, ultimately as it got to the Supreme Court. But that case really was the case that kind of set everything in motion. Until then, college sports had been basically singularly managed by the NCAA, and television was one of those components that was. Board of Regents opened the door for the proliferation of television that ultimately, while it took some time, it led to greater revenues in college sports. And as you saw that economic evolution, that also demonstrated what the college athlete also, as that college athlete is part of that, and part of that economic evolution where revenues are starting to grow, you would see sort of that continued battle. And so I think, as time went on, and certainly in the last 10 years, since the O'Bannon case was decided in the mid-teens, and then you saw the Northwestern case with respect to the first time you started to see the LRB getting involved in the designation of whether or not that's the case. Ultimately, as that progressed as well until you got to 2023 with the Jennifer Abruzzo memo, you're starting to see that definition taking shape as to whether or not an athlete is an employee. We've seen some pullback now on some of that discussion now, but certainly as our panel before us talked about, and we'll talk about a little bit further, The Johnson case obviously still remains out there with respect to FSLA standards and whether or not that designation gets there. So I think that they're all three, I think, are a core part of this. And I think they all, to me at least, the tie to all of those is kind of the economic evolution of sports, of college sports in particular. And so that's how I think, again, I think hopefully it's safe to say that all three are part of this right now.
I see. Thank you so much for that. Professor Edelman, could you share some thoughts with us about this? What is the nature of this conversation when we're talking about college athletes? Yeah.
Well, typically, if we think back, what it really means to be a lawyer, plaintiffs don't usually come to you and say, I'm a victim of an antitrust violation, or my labor rights are being exploited. Plaintiffs typically find something that's unfair. Now, the job of the lawyer is the unfair behavior through a lens. While my classical training is in antitrust law, I began my career at Skadden Arps. I tend to look at things foremost in antitrust. But let's be really clear about this college system that was created. You had about 1,000 member colleges who got together, who passed a series of rules that reflected behavior not only at their home institutions, but all of their rivals. And not all of the 1,000 schools are the same. There's a group of, and we could argue about the exact number, but somewhere between 75 and 100 colleges in America, in somewhere between 2 to 4 sports, that for sure over the past 40 years, with increasing evolution, have chosen to run these college sports programs as cash cows that both maximize revenue for the university and serve as ways of marketing the university. And I'm just going to pick one school and one sport to make the point. At Ohio State University, the football program, I'm only talking about the football program at Ohio State University, brings in upwards of $150 million per year. Now, to compare apples to apples, Ohio State University is in Columbus. There's also a professional hockey team in Columbus, the Blue Jackets. The Blue Jackets play an 81-game season. Ohio State plays about a 13-game season. Ohio State football brings in more revenue in their 13 or so game college football season than the Blue Jackets bring in 81 games. And yet, historically, the football players on Ohio State University have been given a cash payment of $0, or if you want to say a cost of attendance. Now, why has that come to be relates primarily to antitrust law and other laws as well. The antitrust problem is the 1,000 or so schools have reached an agreement with one another where they say not only will we not pay our athletes, but nobody else can as well. Which looks like a classic antitrust violation. We have a labor law question emerging as well, that when these football players come and play at the school and are providing a service for the school under very legal test of being an employee. And if we want to be very fair with ourselves, beyond the legal questions arising out of antitrust and labor law, as much as colleges purport to care about equity and inclusion and racial justice, the system that's put in place for these colleges is disproportionately affecting low-income, first-generation college student and disproportionately Black athletes that are serving as a labor force in behind a high-revenue enterprise that's being disguised as something non-commercial and is being called student-athlete to avoid recognizing that the schools are running commercial sport. And that's how I look at beginning at the issue, that antitrust and labor and name, image, and likeness, right of publicity, are tools to try to bring equity under the legal system. And the violations that are underlying these things are the reason why we have systemic inequities in something that's being run by our very own universities.
Thank you so much, Professor Edelman. Professor Edelman, something you mentioned brings to mind something else. You uttered the phrase equity and inclusion, and I can't help thinking about, for example, Title IX and the role of women. So I'm going to bring this back around to Attorney Cooper and get back to you, Professor Edelman. Given the remarks of Professor Edelman and the suggestion that there may certainly be some equity, inclusion, and justice implications to the ways in which college sports have traditionally behaved, what is the role of Title IX in all this thinking? Because I think certainly while it's the case that women have seen broader engagement in the athletic sphere, it's nothing like what we're seeing for male athletes. So what is the role of Title IX, and how should we be thinking about these issues if you include issues around equity, inclusion, and the role of women in college athletics? And so, Attorney Cooper, could you give us some comments on that?
Yeah, that's a very interesting, it's a very interesting subject. Obviously, look, with respect to the House settlement, one of the things that was that Judge Wilkin indicated was that the House settlement would be subject to initially would be subject to just the antitrust portion of it, which then opened the door for ultimately looking at how was Title IX going to factor in? And look, there are 3 cases now. They're at the appeal stage in the Ninth Circuit where they're looking at that particular issue. And the issue that's really at issue right now is how the settlement was built with respect to the revenue share. As the previous panelists talked about, and we'll talk about in further detail, the House settlement was built upon primarily on media revenue sharing of the institutions and the conferences, and that would be shared with the student athletes. Ultimately, because of that, the lion's share of the revenue was proportionate to the lion's share. The revenue share would be proportionate to the sports in which that revenue is gained. And so right now, obviously, football takes up about 75% of the revenue share. Men's basketball is at 15%. Women's basketball is about 5%, and other sports or Olympic sports are at about 5% as well. Necessarily, because men's basketball and football are men's sports, that's 90%. And that's been the concern as to whether or not, is that an equitable distribution of that revenue? There are, I think it's certainly, it's not an open and shut issue as to that, because even getting back to Professor Edelman's points about proper compensation of labor and work, and whether or not you're receiving proper revenue. And I think, I want to say that one of the GCs in the previous panel also talked about this as a potential, looking at potential options on how you would value this, and the concerns you'd have would be one of the following, which is if football is taking up the lion's share of the revenue, do those players get a corresponding revenue allotment associated with football? That necessarily is going to be that it means that male student athletes are going to get more revenue, and so I think that's going to be an issue that's going to continue to have to be addressed, and it hasn't been, and that's why we're seeing kind of that component. One of the other components, though, part of that, and in our discussion regarding how this plays into employment law and into labor law and the designation of a student as an athlete as an employee, also gets into whether or not where would Title IX factor into that as well. Now, if we start looking at it from a wage standpoint, and now you're looking at equal wages, does Title IX, which really kind of speaks more to allocation of equal opportunity and equal allocation of educational benefits, does that factor in? So right now it's a very interesting component. It's one I think that we all kind of saw when the House settlement was coming through, like, okay, Title IX is there. How is this going to also be factored as well? And I think, as we walk through these things, we're going to see some more of it. But I do think that it's going to continue to be an issue, and we're going to see those appeals. It's going to continue to be an issue going forward. And one that I think that will tie into, more so if we're talking about antitrust or labor, it's going to tie into one of the labor component as well. And so we'll have to see what happens in the next months or so as these cases are moving forward. But it definitely is. It's still something that's out there, and it's still an impact.
Wow, thank you so much. And I have to say, while it might be an inapt analogy, I can't help thinking about the allocation of the tip pool in a fancy restaurant where you've got the servers making a bundle and the back of the house folks who don't have those opportunities, but who work just as hard and keep the place going. But Professor Edelman, your thoughts on this, on the role of Title IX and this whole discussion about athletes and wages and employment?
Well, if we want to have this conversation about Title IX, I think we need to go back to 1972 and the passing of the statute. Title IX of the Equal Opportunity Amendments was intended, Equal Educational Opportunity Act was intended to create equal opportunity in education for men and women. Now, we've come a long way, maybe not as far as we should in society, but we've come a long way. This goes back to the point in time where certain STEM courses an equal opportunity to women. And the statute was geared primarily as a statute based upon education. Whether it related to athletics or not was a subject of debate when Title IX was first passed. And I want to be incredibly clear about something, and I think the history is important. Whereas the colleges now are using Title IX as this theoretical shield about why they say they can't pay or pay equitably to the male athletes, the colleges oppose Title IX in this incipience. And when I say this, if you don't believe me that the colleges fought against against Title IX's application to sports, go on to Westlaw and look up the case Califano, Califano versus NCAA, where the NCAA itself sought a court order not to have to comply with Title IX. Now, the court ultimately found that the NCAA did not have standing to challenge that issue. They said a school would have to challenge it. The University of Georgia briefly thought about doing so, and then all the colleges realized to walk away from this. But it's worth noting that the same institutions that are saying Title IX as being the barrier to compensating revenue-generating athletes fought against Title IX. The implications about Title IX in terms of unionization, the panel, Professor McCann and I, along with Professor John Holden, published a law review article a few years back called The Employee Athlete. And we looked at the standard for college athletes to unionize. Maybe Mike will talk about, we thought, Mike, John, and I all thought we were going to come down a little bit differently. We were in lockstep with one another. That the standard for an employee is one who performs a benefit under control. And in essence, you're able to parse these issues. Most college athletes are operating under the control of the school. The benefit is a different story. And there are certain sports programs out there where the existence of the program is to bring in revenue for the university, where tickets are being charged to attend games in a way that would not be charged for a usual student event, where they're being broadcast on television in a way that a regular student event like a cappella would not. And those athletes tend to meet the definition of employee. Many other college athletes, in the view that Mike McCann and John Holden and I came down with, we do not believe they met the definition. So whereas there's currently a litigation going on right now, Johnson versus NCAA, where the plaintiff's lawyers are trying to say all college athletes, we don't think it's an all or none issue. We think it has to be parsed. Now, that's not a male-female issue. It's a generation of revenues for the school versus not generating revenues for the school. Now, a few complicating factors. One is, I do believe that some of the women's sports programs in this country certainly could generate revenue for their schools. And I think that's been shown lately with volleyball. I think at University of Iowa, beginning in the Caitlin Clark era, it's shown that there's a huge demand. Historically, one of the reasons why I think the women's sports programs have generated so little revenue is not that fans are not interested in women's sports, but the colleges themselves have not put the money and effort into marketing the women's programs. Now, that's not on the athletes, and I don't think we should be playing this game of pitting revenue-generating athletes against non-revenue-generating athletes or male athletes against female athletes. I think the colleges need to acknowledge that the issue in terms of employee status is revenue generation versus non-revenue generation. And it's the obligation of the colleges themselves to market and provide equal opportunity to women and men. They didn't want to do it in 1980, and I still believe they're not doing it today. I find it to be a bit disingenuous when the colleges now to try to triangulate the athletes against each other when some of their leadership is more responsible for the Title IX issue, and it's the colleges that are responsible for complying with Title IX, not the athletes, not the court, and not any theoretical collective bargaining unit itself.
Wow. Thank you so much. I want to switch gears here a little bit, though I think in some ways it's still related. I want to talk about name, image, likeness, or NIL. Could you share with me, both of you by turns, what's the range of opportunities, effects, challenges that athletes are facing with the change in NIL rules over the past couple of years? And we'll start with you, Attorney Cooper.
I think, look, in the last 5 years, thank you, Dean. In the last 5 years, you've seen this potential, this shift, obviously, since the first rules in 2021 were allowed, where you're seeing a greater sophistication of the college space with respect to athletes and their ability to utilize that value. I think what's interesting about it, and I think, what has really kind of transcended from this is the fact that you've expanded the tent for individuals to gain a platform in order to receive additional revenue. Yes, there are individuals coming from disparate backgrounds, but I think in my years at sports, one of the things I've noticed as well is that both as a team executive and at the pro level, is that players, over time have become much more sophisticated as to learning about what their platform can be and how they can utilize their brand and image and likeness in order to gain additional value, and then utilize that value for other things that may be beyond sports. And so I think what I see in this space and what excites me about the NIL space and the opportunities there are that you're seeing that potential diversification in platform building by student athletes who are able to then go and ultimately market themselves, and quite frankly, look at college now and look at the college space as potentially the platform for which they can ultimately see success, even outside of the athletic realm after college. So it's not just NBA or bust or NFL or bust for players. They can now. We're opening the opportunities for those individuals to do things. And I want to just go back to what Professor Edelman just said a couple minutes ago, a little bit, because I do think it's a point, and I was remiss, quite frankly, as a former pro executive, to not state that. He is correct about the ability to market sports and the ability to market sports that, quite frankly, have gone underutilized. I think you're going to now see that because of the economic necessities from college programs, they're going to want to do that. They're almost doing it out of necessity, but quite frankly, you're right. They're missing out on an incredibly large component. Now, back to this component, that is back to what we're talking about with opportunities. Because of that, you're going to see, I think, the students also taking a much more proactive stance on saying, hey, I think I can expand my brand and I can expand what I do in this space in my sport, which may not necessarily be a rev generating sport because of the opportunities that are there, and I can go out and find those things as well. The one thing I think that's going to be critical in all of this right now, and I know we'll probably maybe get into additional detail, is because of right now, things have happened so quickly over the last 5 years. In the sense that one of the things that I do think that the student athletes also will benefit from certain guardrails. One thing in particular is representation of athletes, representation of agents, both certification and knowledge base. And so I think those are some things that just still need to be mapped out. But I do, again, I tend to be a glass half full individual, and I think that what I've seen in the last 5 years is I've seen a growing knowledge base at a younger level of both students who are entering college and those who are there who are now looking to themselves, hey, how do I manage this, and how do I manage this in a way where I can just, again, build that platform for not necessarily going to the pro level, but quite frankly, just simply being able to exit college with a degree, no debt, and quite frankly, some money stored and move forward. And so that's what I think is exciting to me. And I think as that tent expands, that's going to be the thing that I'm really going to be looking forward to seeing. And that's why I think NIL has really started to move the needle a bit there. And I hope we're going to see more of that in the future.
Thank you so much. And I just want to tag on to that question, because something you said struck a sort of a chord with me. At Colorado Law, one of the things I've noticed is that when I go online to order a student athlete jersey, they're at varying prices, number one. So even a fourth string volleyball player probably has a nil opportunity, whereas they didn't before. Number one. Number two, and this is why we at Colorado Law have started some student clinical opportunities for law students to help out our athletes. If you're a big name, you're going to probably have that private representation. Students, of course, who are in less popular sports or less successful, they don't have that. And so something you mentioned about guardrails does strike me, and also conflicts. But I'm going to turn to Professor Edelman because maybe we can spend a few more moments after Professor Edelman. Tell us your thoughts about this. Yeah.
Okay. Well, this question and what's happened with NIL is surreal to me, and it's been surreal for two reasons. One, Dean Kronk over at University of Utah asked me if I would be on this panel. Dean Kronk and I have known each other from a former life. We both went to Michigan Law School together. And when I was at 2L at Michigan Law School, I wrote my student note. I had a great professor, Sherman Clark, who taught sports law, and he supervised me in writing it. Didn't necessarily agree with me, but definitely supervised me, which I give him even more credit for doing. And it was called Reevaluating Amateurism Standards in Men's College Basketball. And the theme of my article was that when the NCAA member schools got together and reached agreements that prevented the athletes from engaging in third-party endorsement deals, that amounted to a violation of antitrust law. Now, it was based on that article that in 2019, I had the opportunity to work with Nancy Skinner's office and advocate for the Fair Pay to Play Act, which made California into amongst the first states that ensured college athletes had the right to endorse products for money. Just to be clear, and I agree with everything you've said, I agree with everything Brian said, but so many people have a misconception of what NIL is. So I want to make a few corrections for people. First, NIL didn't emerge in 2019. If we wanted to pick a year that NIL was created, it would be 1953. And if you're asking me why I say 1953, it was the Second Circuit Court of Appeals decision in Halen v. Topps, which said, at least under the Second Circuit view, a famous individual has the right to control monetarily their name, image, and likeness, and license it or not license it. And that's classic intro to intellectual property. Now, the reason why, despite Halen v. Topps and its progeny, including Zucchini versus Scripps Broadcasting, which came down from the Supreme Court in 1977, that as recently as 2019 or 2021, you choose the year, college athletes did not have the opportunity to endorse products for money, had nothing to do with any law whatsoever. It had to do with the fact that the 1,200 or so NCAA member schools reached an agreement with one another in which they all said, not only will we not allow our athletes to do it, but we won't allow you to do it either. So California's law and Florida's law and all of the other laws that went into place, in essence, made it illegal for any college or athletic association, public or private, that operated in the state to disallow their athletes from having the rights that naturally would have existed for them. And the NCAA member schools, which rarely change their rules on their own volition, in the aftermath of Alston, which I believe Brian spoke about a bit, recognizing that indeed this was likely an antitrust violation and that they couldn't fight with individual state law, dropped that regulation. So that's one thing I wanted to clarify. The second thing I wanted to clarify is, what is this thing that we call NIL? And I think Brian was beginning to get at this. NIL technically means name, image, and likeness. So that should be payment for using one's publicity for commercial gain. So if a college athlete did a commercial with Coca-Cola, that clearly is use of their likeness. If a college athlete is getting paid by their school to appear on a broadcasting or on an ad, that almost certainly as well is name, image, and likeness. Now, some of the other things that we are seeing that are being called name, image, and likeness are really pay for play. Now, the view I've come around to, and this wasn't my view necessarily when I wrote my note in 2002, it was definitely my view by the time I wrote a short treatise on amateurism and antitrust law, which I published in Case Western Law Review in 2013, is that it was not just the outer fringes of the NCAA rules that violated antitrust. It was the whole shebang. And the restraint on endorsing products for money likely violates the rule of reason. So does the restraint on direct pay. So both these things I'm a proponent of in terms of being a proponent of free markets. But I think if we want to have an intellectually honest conversation, we need to separate the two. Which one is payment for use of name, image, and likeness, which I think there should be a free market for. The other one, which is pay for play, which I would support a free market for as well. But if you look at the NFL, now, how do you get to a collective bargaining relationship? Well, first, you have to have a group of athletes that want to unionize. And then second, you can't fight against it. I saw the last 10 minutes of the panel before, and I had a chance to listen to the University of Utah athletic director speak for a few minutes. Now, I'm not going to turn this into the private equity panel, but I will say that if public athletic programs spin off their assets into private LLCs, it would certainly facilitate the process of the National Labor Relations Board taking jurisdiction over a multi-employer bargaining unit of college athletes by conference, by sport. And that would certainly facilitate something that looks a lot more like the collective bargaining that I know Brian and others have worked on when they've represented what we call professional sports. So I'll stop there because I don't want to be long-winded and let you proceed with your next questions, whether they're related or not.
Yeah, my next question is somewhat related, and it goes back to what you were both saying. I guess a significant concern that some people have expressed on this topic is there an inherent conflict when a student, there's student as athlete, student as entertainer, but also student as product? Is there a conflict between the student's role on the team and the very real fact that if you play well, if you've got a great personality, you are a potential big nil property, for example? Are we opening the door to the creation of sort of conflicts between the student athlete and the institution? And this is part of a larger question later. Are colleges and universities disadvantaged by this? Because, for years, people have said, oh, I hate that athlete. He's such a hot dog. Well, now there's money in being a hot dog, right? Is that an inherent conflict? Are the colleges and universities at a disadvantage, or are the power dynamics such that we don't have to worry about that? Attorney Cooper.
I think it's, Dinas, I think it's closer to the pro model to that end, right? Because I think, one of the things I do, and Professor Edelman brought up a great point about the fact that NIL is in its truest form is endorsement deals. It's licensing. It's not, again, to be clear, it is not pay for performance. We've seen that line kind of blurred more recently, obviously with the Sorsby case and the Mensa case, where you've got institutions and there's, these concerns about transfer portal movement and the ability to try to utilize a license in order to essentially also potentially maintain whether or not, maintain a student athlete to be there. So I think, that line continues to gets blurred. And to your question about the potential conflicts, I think that you can look to the pros for something more like that. One of the other things I think it's important to note is that basically, we are talking about we're not talking about there's opportunities that are growing for a larger number of athletes, but all in all, the average amount of NIL revenue that a student athlete may receive is still in the four figures, right? So I mean, while you have the big cases, right? And so I think that for the most part, many players who play even Division I college football, some play without receiving any NIL compensation. That's not something that's negotiated, and that's not something they get. They come and they play for their scholarship. I think over time, when you're talking about how, marketing out, quote unquote, maybe your star players, I think that conflict necessarily happens at any level, at the pro level as well, right? When I was team president of a team, you wanted to make sure your athletes were, the athletes or the pro athletes were also brand ambassadors for your team. So you wanted to work hand in hand to make sure that they were advancing the goals, of our revenue goals, which were obviously to advance ticket sales, to have meaningful partnerships. And so I think that they both work together. I think sometimes the conflict, the true economic conflict, can come when you do have a student athlete who has a third party deal with a conflicting partner of an institution. The early days of NIL, right? You had those state NIL laws, and you had your universities had their own regulations as well, and some of those things were addressed in that, right? Well, the school could still weigh in on a third party deal for one manufacturer if the school was with Adidas and the student athlete wanted to sign a deal with Nike. That's something that the school could essentially address. I think how that's also been rectified at the pro level is that ultimately those rules were came together and that there was greater allowance of that with respect to making sure that the economic interests of both parties were being respected. I always harken back from the pro side to the famous picture of Michael Jordan at the '92 Olympics. Right, he's a Nike endorsed athlete, but at the time the U.S. Olympic team was wearing Adidas warm-ups, and what does he do? He has the iconic pose of having the flag over his, as a great shot, but it also covered up the Reebok logo. I think that schools are going to be able to start working with their student athletes to start getting through those things so they can maintain both their economic interest there. And I think that's going to be one of the larger conflicts. One last thing I wanted to talk about, you had mentioned kind of like, I think you alluded to kind of maybe more the personal conflict, quite frankly, also of having those players. That's something that has intrigued me for a while as to whether or not over time, do players start to wonder about, well, hey, why is he receiving all the accolades? I think that give and take is also true at the professional level, and players have generally worked through that. I think over time, what is different about college right now that is not in the pros, and this is one of the things I think that again that the big picture the big issue that we haven't really talked about is how that ties into collective bargaining and minimums and potential compensation minimums and those types of things that you do see at that pro level, where the players seem to be working obviously in together collectively, regardless of their stature on a particular team, for example. That I think hopefully will, again, we are, I think one of the things I also want to be clear about and be to our group as well, and I know there's tons of questions ultimately coming forward. We are at the beginning stages of this, right? And then I think I would be remiss to say that there are going to be some bumps along the road. We have seen that in the back and forth between club and league at the pro level, and I think you're going to see that here at the college level as well.
Thank you so much. And I don't know, it looks like we might have temporarily lost Professor Edelman. We'll keep going and assume that he's going to be back with us. As we are sort of getting towards the end of our time, and I want to turn to the audience shortly, what do you see as the long-term outcome in terms of the change in the relationship between the students and the university, colleges and universities? Where are we going with this? Meaning, is this a fad? What is this moment that we're seeing?
I definitely don't think it's a fad. I think the GC from Christopher from Baylor brought up the thing I think that going forward is going to be that I see going forward is how are we going to ultimately get to a point where we can rectify the ability to the leagues have had in sports, leagues have had this structural component of making sure they can have regulation in place that allows for competitive balance. And you need to have competitive balance as a sports league. I mean, Justice Stevens said it back in 1984. The NCAA's kind of leapfrogged on that and used some of that to justify some of their pro-competitive justifications for it going forward. But believe it as it may, a sports league needs to have competitive balance and needs to have certain restrictions and rules in order to survive as a league. There's no question about that. The question in antitrust always becomes whether or not that anti-competitive rule deserves a pro-competitive justification. Is it balanced out? Is there a less restrictive alternative? I think the question now becomes, and even from the legislative standpoint, from all of the things we're looking at now, the question becomes: can a legislative body, either the NCAA, the College Sports Commission, but can they, the conferences themselves, can they make a regulation that would survive antitrust scrutiny? And everyone, we've seen legislative remedies associated with that as well. But I think what we're going to see, and I'll not see Professor Edelman's back. I will. The thing I would say to wrap up here is that I think going forward, we are going to see some sort of graduated ability, a collective bargaining ability of student athletes. If you genuinely want to not have an issue regarding antitrust, that's how the pro leagues all got there. They all had to ultimately work their way through getting to a stage where they could make an argument regarding working conditions, and ultimately that graduated into not just working conditions, but also who's sharing the revenue, how they're sharing it, how those things occurred. Most famously, right, the NFL ultimately had a prolonged labor dispute in the late '80s, early '90s, but that ultimately morphed into the NFLPA decertifying, and then ultimately you had the Powell, McNeil, and the White cases that ultimately led to NFL free agency. I think you're going to see something along those lines here, where there's going to be this continued thing: how do we better build college sports in a way where we can regulate properly, or regulate in a way that's meaningful and makes sense and it's not exploitative, but at the same time also allow for the continued rights. And I think that they're going to have to get there. The only thing I can think of is can we figure out a way where we can? And again, I wanted to get I thought Chris was kind of going there with that in the previous panel. Is there sort of a hybrid approach where you have allow for some level of collective bargaining, and perhaps it's collective bargaining even among the rev share, the revenue generating sports to begin with. So you don't have like this, and I think GC Cornell mentioned this as well. This concern about how you would be classifying employees going forward, but you have something sort of like that there, where you can have that dynamic, and then also allow for some effective rulemaking, so you can have the regulation of agents. You can have a situation where you're also protecting the interests of both sides going forward. So. We are, again, I think if this is a 400-meter race, we are entering maybe the first turn at best right now. I think we're outside. I think we're out of the blocks, but we are by no means close to this finishing. And so that's, I think it's going to be very interesting to see going forward. But I'm sure Professor Edelman, I know you've got some insight on this, but I think that's how I see things going forward.
Yes. And so, Professor Edelman, thank you. You're back. I just want to follow on with this question that we just discussed. So the long-term outcome and implications of what we've just talked about. I could be a skeptic and say, it's a fad. This conversation won't be happening in 5 years. Attorney Cooper seems to be saying that's not what's happening. We're at the beginning of this race. What are your thoughts in terms of sort of understanding the rights of athletes versus the colleges and universities when it comes to athletics? Yeah.
Well, I first apologize about having unstable internet today. I'll try to be more stable than my internet service in giving you this answer. The problems could go away very quickly if colleges come to accept real legal advice as opposed to pipe dreams. I've been writing about the issues in the college sports space for upwards of 20 years. And colleges throughout the country typically say things like, our professors, people should listen to them. Colleges are not listening to me or Michael McCann or John Holden or Jeremy DeRue or any of those of us who've been writing seriously in the field. For nearly 20 years, I've been giving 2 ways in which colleges could avoid the problems that first very clearly were coming for them, and second, resolve them once they came. And there are 3 really very real options for any college. One, nobody says you have to have big-time commercial college sports. I happen to love the University of Colorado. I know that's where you're dean. My wife is an alumni of the University of Colorado. It's so great to go hiking in Chautauqua and then go to a game.
Yes.
University of Colorado has partnerships with PointsBet and sports gambling. They sell beer at the games. They've chosen to create a commercial revenue maximizing environment. So one of three options, and I don't think any college is going to take it, is don't do that. Go back to creating something non-commercial. University of Chicago walked away from it. NYU walked away from it. Don't be this. Now, option number two is an antitrust solution. I'm looking right now, Dean Innes, at your backdrop, and I see 12 schools, and these are the Big 12 schools. And it's a shame I didn't go first because I wish we had the chance to ask this to the general counsel. As bullish as I am on antitrust litigation against the NCAA and their member schools, if the 12 schools whose logos are on here got together and reached an agreement, whether it was an agreement to limit college athlete pay or an agreement with respect to eligibility, and it's just those 12 schools and nobody else, I am pretty sure they could. Chover's Ivy League said a member conference could probably do this. Now, antitrust challenges against college sports because they're under the rule of reason. And one of the prongs to violate the rule of reason is you need to have market power. And a reasonable argument can be made that any one of these member conferences don't have power to control the market because they compete against the other conferences. So if the 12 of you guys here came to what I think is your senses, and maybe I'm saying that off the cuff, but I've spent 20 years of studying this, and said we're not going to support rules on the national level, we want to make rules amongst the 12 of us, I don't think you have an antitrust problem. So those are two potential outcomes. One, walk away from the commercialization. If it's not commercial, you won't have an antitrust issue and no one's even going to want to bring a case. Two, have your rules, but have your rules on the conference level and deal with the fact there'll be interconference competition. And three, and Brian began to allude to this, is the professional sports corollary, which is negotiate them through multi-employer collective bargaining. Now, people don't talk about this. Usually companies don't want their employees to unionize. But in the NFL, after the work stoppage in the early 1990s, the one that Brian alluded to when he just in all those cases, as part of the settlement, the players agreed to reunionize. And it's pretty well acknowledged that the football teams themselves wanted the players to reunionize so they would be able to collectively bargain over rules related to salary and eligibility, trust liability. It continues to confound me why commercial revenue-generating programs in generating sports continue to fight against the possibility of college athletes unionizing. When Northwestern University decided that they were going to fight against efforts by Kane Coulter and their football program to unionize, Northwestern blew it. They might have done what the NCAA wanted them to do, but if they were able some way to, instead of fighting against it, kind of encourage a union, but it to be the entire conference and maybe try to create a body and get into some form of multi-employer bargaining, perhaps with the conference being the bargaining unit, which is private, they could have avoided all these problems altogether. And when we hear the general counsel of Utah talking about, and I don't care if you do it with private equity or not, I think you certainly can do it with private equity, but this notion of creating a spin-off entity, thus that the public institution is spinning its property into a private entity, which undoubtedly would fall under the jurisdiction of the NLRA, supporting the notion of college athletes unionizing in the revenue-generating sports, again, would get you out from antitrust and would lead to collectively bargained solutions. So I'll be honest, I know very little in this world about very few things. But I've spent the past 20 years on this one little dot. And these are my three ways to resolve the problem in this one little dot. I think the time has come for colleges not to stop choosing the silent fourth option of running to Donald Trump and Congress and praying someone bails them out from having to follow the same laws as everybody else follows. I think the time has come for them to take a look at the roadmap of what the real opportunity set is to accept the fact that sometimes their own professors say things they don't want to hear. But college and university presidents need to understand hearing what you don't want to hear doesn't mean that it's wrong. Start accepting the legal environment and picking one of these three very plausible solutions to move forward to. And the quicker they do that, the quicker we'll have stability in college sports.
Thank you so much. And Professor Edelman, and Attorney Cooper, I'm going to thank you so much. We are out of time. You have just been incredibly enlightening with your remarks. I'm going to turn this back over to move to the next panel. But I just want to mention a really weird quirk. The Big 12 actually has 16 schools in the league and 11 law schools. So that's one of those trivia questions that you might get on Jeopardy or something. Anyway, thank you so much, gentlemen. Moving back to Dean Baynes. Bye-bye.
Thank you.
Thank you, Dean Buckner-Innes and the panelists. Now comes up our third panel, which will be discussing cutting-edge issues in collegiate sports, dealing with several academics. The moderator of the panel is Elizabeth Cronk-Warner. She's the Jefferson B. and Rita E. Fordham Presidential Dean, Professor of Law at S.J. Quinney College of Law at the University of Utah. She's nationally recognized expert in the intersection of environmental and Indian law. She's taught courses in property, Indian law, environmental and natural resources law, and supervised the Tribal Judicial Support Clinic at the University of Kansas School of Law. She's received several teaching excellence awards, co-authored several books on environmental issues and Native Americans, and has over 40 articles and book chapters to her credit. Let us welcome Dean Cronk-Warner, who will introduce the panelists for our last panel. Thank you.
Great. Thank you so much, Dean Baynes. And I just want to say a big thank you to the University of Houston for hosting today's event. I have really enjoyed the conversation and am excited to have the opportunity to participate in this last panel. So we have, to kind of sum everything up, it would not be a law dean's conference if we didn't have an academic perspective. So having now heard from our university representatives, individuals thinking from the player perspective, we're now going to present two different ideas from more of an academic perspective. And I'm very excited to have with me today two amazing law professors working in this area. So the first to speak is going to be Professor Maureen Weston. And she is a professor of law at Pepperdine University Caruso School of Law and director of the Entertainment, Media, and Sports Dispute Resolution Project. She received her JD from the University of Colorado and a BA in Economics and Political Science at the University of Denver. Professor Weston teaches courses on arbitration, mediation, negotiation, international dispute resolution, legal ethics, and U.S. and international sports law. She serves as faculty advisor to the Sports and Entertainment Law Society and Dispute Resolution Journal, and as coach for ICC mediation advocacy and sports and entertainment law negotiation competitions. She practiced law with Holm, Robertson, Owen, and Faegre and Benson before joining the Academy, both in Colorado. And she has served on many committees, including, for our purposes, the ALS Sports Law Executive Committee. She is a member of the board of directors at the University of Colorado School of Law Alumni Board, the National Sports Law Institute at Marquette School of Law, the Malibu Little League, and editorial board of Law and Sport. She is a frequent speaker at conferences and has co-authored several case books on sports law and arbitration, and has written numerous articles in the area of Olympic and international sports arbitration, disability law, sports law, and dispute resolution. So I'm really happy to welcome her, and I will give the bio for our second speaker, Professor McMahon, before he begins his presentation. We're going to have a little bit of a different format for this panel in that our speakers are going to speak up to 15 minutes. When my face comes back on the screen, they'll know that they have 1 minute left. And then we're going to answer your questions at the end. So with that, Professor Weston, take it away.
Thank you, Dean. It's an honor to be here and to hear about the impact that the House settlement and the new NIL era is having on the Big 12 and college sports all across the country. I don't want to repeat a lot of what was said by the general counsel. We didn't coordinate exactly what we were supposed to be doing, but here's the academics perspective, right? We're hearing about these athletes making loads of money, but it's not all of them are making money, but there's so much focus. I guess from an academic perspective, and I'll get into my presentation, but from an academic perspective, the hyper focus on sports. I haven't heard anyone talk about education or the athletes who are when you used to watch these games, they would say so-and-so's a communication major, so-and-so's doing this. Now the athletes are taking classes online, and they don't even want athletes in the classroom because they're concerns about betting. And is so-and-so going to be asking the athlete questions about what the line, who's injured, and the resources that are being spent. So there's a little bit of that from my perspective. I'm trying to get money for my moot court team to travel to go to these competitions. And meanwhile, our fundraising is focused on sports. So, and as the counsel from university said, yes, when the job of a university president, right, is football for the alumni, parking for the faculty, and parties for the students, or pizza for the students, but that hyper focus on sports. And it's always been that way, but it seems to be quite extraordinary right now. So the new era in college sports is not, from my perspective, not necessarily the most improved era. Now, do the athletes deserve to be compensated? Yes, all of the restrictions, it's time, but are the schools supposed to be the ones brokering these deals, acting as their agents, versus the professional sports model where we'll pay you for what you do as for the team, and then get your own endorsement deals or form a union and have collective bargaining negotiations. That seems to work in professional sports. Uniquely, that's not possible in college sports because what the employment question, public universities are subject to the National Labor Relations Board. Professor McCann's going to be talking about the employment question as well. So the state of college sport really is, how rich is your donor? We've seen Indiana come from nowhere. They said Nebraska and Indiana. Nebraska used to be the football team, and Indiana basketball. So money can skew. Our Texas Tech has a big Cody Campbell, who is very influential in sports. Is Cody Campbell a coach? Is Cody Campbell administrator? No, he's a booster. He's a fundraiser. You have Larry Ellison at Michigan. So what I need I need an NIL for my students. Okay. And the resources and the support, and let's do legal aid for the student athletes, and let's do NIL deals for the student athletes. All that's great, but what about the regular athletes? And then the funds, if student tuition dollars are going to support the gap in paying for athletes, once again, this is me, right? So, and I did that by AI, which I never used, but I said, give a female professor who's confused, perplexed by college sports, and then they gave me something. I said, could you make her look less frumpy? And they said, no, not really. So here we are. But how did we get here? To quote David Burns in the Talking Heads, the NCAA is the association of all the colleges and institutions, nonprofit educational institutions, over 1,200, 500,000 student athletes, 25 sports, part of the higher educational program. Yes, they've had restrictive. This is what the membership, the NCAA isn't from down high. It's the members who make these rules. We can't afford to pay our athletes. We don't want to commercialize. We don't want exploitation of athletes. We shouldn't have agents. They need to be students and athletes. It's part of the educational experience. So that's that used to be in the first part of the NCAA Constitution. But at the same time, right, college sports is taking off $1 billion revenue from the March Madness, and coaches are making millions of dollars. They're the highest paid public servant in many states. And so you see the money coming in through the NCAA, which makes its money primarily from the basketball tournament, and then the college football playoff. And the NCAA gets wrapped up into the college football playoff, but they do not share their revenues. So those schools, because of this case, 1984, I used to work at University of Oklahoma, and Dean Coates, who brought the Board of Regents case versus NCAA, which was the groundbreaking Supreme Court case saying that the NCAA, at least with respect to its media plan and TV deals, was engaged in commercial activities and subject to the Sherman Antitrust Act. Of course, it had the mantra down there that the NCAA latched onto, that athletes might not be paid. But Dean Coates later said, I'm not sure I did the right thing bringing that case, but he brought it, and it's here to stay, and it really provided the foundation for the rest of these cases that we've talked about before. Jeremy Bloom out of Colorado was a professional world-class skier, and he wanted to play at the University of Colorado football. He didn't ask CU to get him. The only he wanted was a waiver from the NCAA's no endorsement rule so that he can compete as a world-class skier in Olympic sport. He gets his own endorsement deals. That's where the Court of Appeals of Colorado said, no, the NCAA has this rule, and we're going to enforce it, basically because they have the right to, looking at the dicta in the Board of Regents case. Then, of course, the video game O'Bannon, but both O'Bannon and Alston were framed as restrictions on education. At least they came out as education related. So it was against violated antitrust laws to put restrictions on the cost of attendance or education related benefits. At the same time, Jeffrey Kessler was arguing before the Supreme Court, and they asked him, is this all you want, just for the athletes to be able to get violins and computers and maybe some study abroad? He says, yes, this is all we want. The Jenkins case, the House case, was already in the hopper. But the Supreme Court, who can't even order pizza 9-0, decides in a unanimous decision, they bashed the NCAA, and especially Kavanaugh with his concurrence. The next day, the Fair Pay to Play Act, which were supposed to be effective in 2023, they accelerated those for the day after the Alston case. So now state laws saying schools can't restrict payments to NIL payments to players. Concurrently, the transfer portal. So you have this perfect storm of NIL deals and athletes being able to transfer. So we have this roster mayhem. The rule is still that the schools can't get involved in NIL deals. That was the NCAA rules. They paused the restriction, but the schools aren't supposed to be involved. But collectives are. So collectives have the power to really pay players, and they're influential in recruiting. And so the schools, and even now, schools are looking to boosters for recruiting to provide the money for the NIL deal. My submission is the intent was never for schools to be brokers for the NIL deals. They should be able to have their NIL, and there was a model law on college athlete NIL where, yes, and we all have publicity rights, and athletes should be able to monetize them. But should the school be involved in spending its resources? And the reason why they want the boosters, that the IRS was getting was looking at these booster payments to NIL. The boosters are used to giving money to the institution, so it can be tax deductible. But when you give the money straight to the athlete, that's not considered a charitable purpose or an act. They try to say charity, do an Instagram or a charitable purpose, but so they're getting into that. So we have this influence of boosters and providing this compensation. Is this charitable deduction? Now what we're doing is the boosters are back to giving, after House, giving the money to the school, charitable deductions. Then the schools pay the player. Unless it's on the cap, then they'll go through that process. But again, the House versus NCAA case was pending during Alston. And once Alston was decided, then House was still in the hopper, and it was filed in 2020. June 6th, it was settled. and again, seeking an elimination, full-blown elimination of NIL. And this is where they went straight for the money. So the back pay damages and the allocation that has been discussed before, and this idea of revenue sharing, which is a misnomer. It's licensing of NIL deals, because not schools don't all have revenue to share. So they're looking to fund that. And then the no limits on scholarships, but instituting roster caps. And then this, the other provision is creation of the College Sports Commission, and which is to police the settlement terms on the revenue sharing, and is there compliance with that? And then second is the this idea of NIL Go. Are these associated party endorsement deals for a valid business purpose and within the fair range of compensation? And you pop it in, the endorsement deals over 600 have to go to NIL Go, and then who knows how long it takes. But there's a criticism that it's taking a long time to get that determination of, is your deal cleared? Is it not cleared? And then if it's not cleared, there's a provision for mandatory arbitration. And it's been mentioned before that the case to watch right now is Nebraska, which was discussed, is trying to shift money from money, its multimedia partner, money going to it, and then having that go to the players. Is that within the standards of a valid business purpose and fair market value? And they're taking this to arbitration. Arbitration, it's a private process. We don't even know who the arbitrators are. This is a brand new process in terms of how the outcome is going to be, but typical arbitration. So subject to the Federal Arbitration Act, and it can be vacated under very limited grounds. So this is where we are here. Last year, our executive order said this is created an out of control, rudderless system in which competing university donors engage in bidding wars for the best players. It's a chaotic race to the bottom. Okay, so how are we going to save college sports? Well, we're waiting on the second executive order that's supposed to sort everything out, but that hasn't happened yet. I do want to talk about and respond to some of the comments on the earlier questions about some of the challenges, and we've talked about the lawsuits that are already pending regarding. Charlie Baker said, I didn't think a result of the House settlement would be that people would never want to leave college, right? So we have the 4 and 5, the eligibility rules subject to I think there's 55 cases at the federal and state courts attacking the eligibility rule. But what about Title IX? And so we saw the 75, 15, 5, and 5 allocation under the House settlement, and what I'm learning from today's session is basically that allocation is still happening with revenue sharing and NIL license deals. But what about Title IX? Title IX is this sentence, right? No person shall be on the basis of sex be excluded from participation or subjected to discrimination under any program receiving federal financial assistance. There was a question. Well, Title IX that's Title IX. Was it intended to apply to education? They said explicitly in 1974, yes, it applies to college athletes. In 1974, again, they tried to exempt revenue producing sports. Rejected. That's the Tower Amendment, where they tried to exempt it. So it says the fact that, is it fair? Probably not. Is it the law? Yes, right? That revenue producing sports don't get special treatment by institutions receiving federal financial assistance. That's the law. Is it fair? Maybe not. Is it the law? Yes. So we have one thing I want to look at now is how are these institutions reporting their NIL license agreements for purposes of the Equity in Athletics Disclosure Act, for purposes of complying with Title IX? How are they responding to that? Right before Biden was out of office, the administration said Title IX applies to NIL compensation deals that schools are providing. That was rescinded a month later after the Trump administration came in. There's pending litigation against the University of Oregon, challenging these NILs and treatments under Title IX. In terms of what comes next There's 7, I've learned, proposed federal legislation. Obviously, we can't even pay TSA. So who knows? I've concluded over the years, like Mark Edelman, I've been looking at this for over 20 years, that when you say the answer is Congress, you're kind of desperate, but these are desperate times, looking at those types of questions. But now we have private equity. Another question I want to explore is the tax exempt status of educational institutions when they're partnering with private equity. And so maybe this is a commercial activity, but in terms of calling ourselves a nonprofit institution, I know it's my time. And other concerns, gambling, athlete wellness and mental health, being an influencer and a student athlete. And this is going down to the high school level as well. That's it. Thank you.
Great. Thank you so much, Professor Weston. I have to say, I loved the AI generated law professor. I think that was great. Really thought-provoking. Again, a reminder, if you have any questions for our panelists today, to please put your questions into the Q&A, and we will answer those or do our best to answer them after our next speaker's presentation is done. So I'm really pleased to have with us Professor Michael McCann. He is the Associate Dean for Intellectual Life and founding director of the Sports and Entertainment Law Institute at the University of New Hampshire. He also teaches at Harvard Law School as a visiting professor of law, and he has also taught sports law analytics as a reading group at Yale Law School. In 2025, Professor McCann won the Association of American Law Schools Law and Sports Section Award, a prestigious award honoring an individual who has made a substantial and significant contribution to scholarship, teaching, and service in the field of sports law. He has been an innovator in legal education, creating the first law school class on name, image, and likeness, producing an IP and antitrust law course at UFC, and designing first-of-their-kind online programs and building the much-publicized Deflategate course. I certainly remember Deflategate. In 2021, he testified before the U.S. Senate in a hearing that included NCAA President Mark Emmert and centered on NIL. And he and former NBA player Ed O'Bannon co-authored Court Justice, the inside story of my battle with the NCAA. The Christian Science Monitor named the book the #1 sports book in spring of 2018, and it led Amazon sales categories. He is the editor of the Oxford Handbook of American Sports Law, and the book is assigned in many, many sports law classes across the country. So we are so incredibly fortunate to have him. Again, he will speak for about 15 minutes, and then we'll open it up to question and answers. Thanks so much.
Dean Warner, thanks so much for the kind introduction. It's an honor to be here. I want a special thanks to Dean Baynes, who, I don't want to make him sound old, but 25 years ago, I was a law student and invited him to speak on a panel. He came and was an all-star. So I greatly appreciated when he invited me now to be part of today's event. And it's an honor to be part of this group. It's tough to go last because everyone's been so great, and I don't want to duplicate Professor Weston's outstanding presentation, Mark Edelman and Brian. I mean, there's so many great presentations. So what I cover will some of the time duplicate what you've already seen, but hopefully I can put it in a way that's a little bit different. And what I'm going to do is try to focus on what I would describe as 6 misunderstandings about legal issues in contemporary sports. So I'm going to pick 6 things. There are plenty of other things that I could talk about, many of which have been discussed. But what I would consider to be misunderstandings about the application of labor, employment, antitrust, and IP laws to contemporary college sports. And let me see if I can get this to work. There we go. One big one, and this has come up, NIL deals are about NIL. This is often untrue, as odd as that may sound, especially in the context of college athletes who play football or basketball at power conference schools. As Mark Edelman eloquently explained, although NIL has become a popular moniker in the 2020s, and it's often framed as a new right, it isn't a new right at all. It's based on a longstanding IP principle, the right of publicity. And NIL, I view NIL as the removal of a restraint. on college athletes to use a right they already had. They can now use the right of publicity without running afoul of NCAA eligibility rules. So all these years in the 70s and 80s, when some athletes could have made a lot of money through endorsement deals and sponsorships, and more recently with the internet, influencing deals, they always had this right, but it was restrained by NCAA rules. So the removal of that restraint really is, I think, the right way of looking at NIL. And some colleges, of course, though, and their boosters through collectives in particular, they're not really using NIL as NIL. They're using it as a recruitment or an inducement. So deals that are called NIL deals, I think in many cases are better understood as pay for play, which of course the NCAA prohibits. So although NIL is allowed, paying an athlete to go to a school or stay at a school is not allowed. And at least some of the times these deals are functioning that way. And I view them more as signing bonuses or even employment contracts. The House settlement is supposed to address this issue through the creation of the College Sports Commission. Maureen just talked about it, and we'll see how well they do. They're a small staff, and they're getting, I think, inundated with contracts to look at. And it certainly seems as if, and from everything I hear, it's still going on, where athletes are being paid through NIL in a way that's much more akin to an employment context rather than an endorsement deal. So, of course, some deals are still legit, and I don't want to imply that all NIL is fake NIL. That's not true. There are some athletes, including at the schools that we all teach at, have signed NIL deals that are much more in line with what it is supposed to be. But to be clear, there are some that are not, and it doesn't appear as if there are consequences. Supreme Court gave college athletes NIL rights. This has appeared in major media articles, literally, top places where you wouldn't expect things to be written incorrectly, but it's been written that way. NCAA versus Alston, as Maureen just talked about, it was an antitrust case. It was not a right of publicity or NIL case. It didn't lead to NIL. It concerned NCAA rules limiting member schools' ability to reimburse athletes for education-related expenses. Name, image, and likeness, NIL, there were 1,300 words between the majority opinion written by Justice Gorsuch and the often quoted concurring opinion written by Justice Kavanaugh. NIL doesn't appeal, name, image, and likeness doesn't appear because the case had nothing to do with those things. So why would it appear? And in ruling against the NCAA, the court made clear that the NCAA is not owed deferential review under antitrust law. The ruling made clear that the NCAA is treated ordinarily. And in a case that's been referenced several times today in great detail, so I'm not going to go into it, the NCAA versus Board of Regents, a case involving not even college athletes, but TV rights and NCAA rules restricting how often a school can appear on TV. And of course, in the course of that opinion, Justice Stevens wrote in dicta that the NCAA's, I'm paraphrasing, owed deference in how they implement rules regarding college athletes. Well, it turns out that was just dicta, as the Alston case made clear. And it also means that NCAA rules regarding athlete compensation are all subject to ordinary scrutiny. Another comment that I sometimes see, extending Sports Broadcasting Act to college sports would be a game changer. This is one that a lot of politicians have latched onto, and I think it's worth unpacking it a bit. The Sports Broadcasting Act, which is from 1961, keep in mind, it provides a limited antitrust exemption to pro football, basketball, baseball, and hockey when they and their teams negotiate TV contracts that provide sponsored telecasting. And I put it in green. My slides aren't as fancy as the ones we've seen, but I hope that stands out by putting that in bold and green. Some members of Congress want to amend the SBA so that it includes college sports. I think for a good reason, in hopes that it would allow colleges and conferences to more efficiently market media rights, generate more revenue to fund women's sports and Olympic sports. I think their heart is in the right place, but I don't think this is the vehicle. As several federal courts have held over the years, the SBA's antitrust immunity only applies to sponsored telecasts. What does that mean? It means free over-the-air telecasts that we could, if those of you that are my age or older, you remember before cable, right? How we watched TV. We had an antenna that picked up signals. We didn't pay for it. You buy a TV, you buy an antenna, maybe you put it on the roof, and you pick up signals. That was the world we lived in. That was the world contemplated by the SBA. Not streaming, not cable, not paid satellite. In fact, courts over the years have rejected extending the SBA to those means of telecasting, which I think is an important point when you look at, let's just extend the act. It's also significant because fewer than 20% of homes in the US even have antennas. I mean, do you have it? Ask yourself, do you even still have an antenna? Many of you are probably going to say no. Sports viewing nowadays is through streaming, through cable TV, through paid satellite. Those aren't governed by the SBA. So what's the remedy? Well, the SBA could be amended to extend to modern means of transmission, but it's not that easy because there's a big case going on. There's an appeal before the Ninth Circuit involving the NFL Sunday Ticket antitrust litigation, where a jury ruled against the NFL, but then the district court judge granted a judgment notwithstanding the verdict and sided with the NFL. That case is about the Sunday Ticket, where NFL teams pool their broadcast for out-of-town fans into one package that people can buy in one deal. The argument is that in a more competitive marketplace, teams would basically compete with each other. So the Cowboys, where they have fans all across the country, would work out TV arrangements in other cities. The league doesn't want to do that. They want to keep territorial rights. The point being, it's not that simple to simply extend the language of the SBA. There would be consequences and there would be clearly debate. The SCORE Act. The SCORE Act would immunize the NCAA schools from athlete lawsuits. The SCORE Act, as several of the panelists have said, involves schools going to Congress and by extension the president basically asking for help. Keep in mind what this act actually says. The specific language of the act might not be the home run that advocates believe it to be. The act would confer antitrust protection to the NCAA and member schools when they establish rules regarding player economics. It would also declare that college athletes aren't employees and that state laws can't conflict with the act. Well, first of all, ask yourself, do we need an exemption? Mark Edelman has written extensively on this. The defendants in antitrust cases almost always win. This is something that we don't necessarily detect that because of NCAA antitrust litigation, but remove the NCAA and go through antitrust law, more ordinary cases, the defendant usually wins. There's data, Maurice Stuckey, a law professor, Tennessee, 97% of the time the defendants win. So think about it. It's really tough to win an antitrust case. If you lose an antitrust case, you must be doing something pretty bad. Antitrust exemptions are also unpopular. As the U.S. Department of Justice bluntly stated in 2021, competition through free enterprise and open markets is an organizing principle for the U.S. economy. Think about what exemptions actually do. They allow those that are conspiring to conspire in ways that undermine competition. Even when exemptions are enacted, the Supreme Court has stressed they must be narrowly construed. We know this from President Trump. In January 2021, President Trump signed the Competitive Health Insurance Reform Act into law. It actually repealed key aspects of the antitrust exemption for the insurance industry, particularly for the business of health insurance. That's gone. So any federal college sports law, I think, has to get over the fact that an antitrust exemption doesn't partner with the trend of antitrust law in the United States. And it also invites the question, why can't you figure out rules? Brian talked about this. Why can't you figure out rules that simply comply with antitrust law? Yeah, you could come up with something that's reasonable. If you can't, well, that actually says something. Another problem, any federal college sports law would face a bevy of legal challenges. Advocates for states' rights would argue that the law interferes with the rights traditionally understood as belonging to the states. including the topics of public university employment and unionization. Those are resolved by states and state labor boards. The right of publicity, which we've heard about, there's no federal right of publicity. It's based on state law. And some states like California have a statute and pretty intricate common law precedent regarding the right of publicity. Not a surprise because there's Hollywood, right? Well, would a federal law conflict with that? Equal protection claims are possible. Why are college athletes being denied the same rights and opportunities as their classmates who don't play sports? Free speech claims. If the law restrains NIL opportunities and interferes with First Amendment freedom of expression, then there are non-delegation problems with legislation that delegates regulatory power to private associations like the NCAA or College Sports Commission. Another thing we've been hearing in the media, Trump executive order is the solution. Probably false. I'm not going to say it's entirely false. It depends on what the order is. But an executive order attempting to create an antitrust exemption from the Sherman Act would be immediately challenged. Ask any antitrust attorney. A president cannot unilaterally rewrite a statute to have preferred policies. Also, the statute is written by Congress, not by the president. Amending a statute also has to go through Congress. As the U.S. Supreme Court recently held in rejecting the president's attempts to impose tariffs through an international emergency act, the president must be authorized by the statute's actual text. Any executive order declaring that college athletes can't be employees or unionized, that would invite challenges under the NLRA and FLSA, both of which govern employment. Statutorily govern employment, which is a key point. Again, you can't go around the language of a statute. And even if an order that college athletes aren't employees survived judicial review, it wouldn't prevent some athletes from being classified as employees under state law. We heard Mark talk about this in the last panel. All 50 states have their own labor and employment statutes, which vary widely and govern employment at public universities. You can imagine public university employment and unionization laws differ from, say, people in South Carolina or those in Minnesota or California or New Hampshire. So executive orders might pursue policies that the NCAA and conferences want, but they're going to be challenged. I mean, the idea that it creates predictability, I think, is, to me at least, a myth. College athletes aren't employees. Mark talked about this, so I don't want to go in. I don't want to capture the eloquent points he made, but clearly this is under attack. Johnson versus NCAA, male and female athletes from Division I programs argue that student athletes are employees within the meaning of the FLSA and state minimum wage laws. What do the athletes want? They want to be paid unpaid minimum wage going far back as 2016. And here they argue that Division I colleges and the NCAA are joint employers, meaning they together control and share responsibility for athletes' scheduling, supervision, and other workplace-like conditions. As stressed in the complaint, NCAA rules apply to all athletes on an equal basis, and those rules govern recruitment, eligibility, hours of participation, discipline, and other items that are commonly understood as employment. The plaintiffs maintain that college athletes are student employees. That's a key point. They're not saying they're going to unionize. They're not saying they should get an employment contract. They're not saying they should be like professors or staff or the deans. They're saying they're student employees in the same vein as work-study students who are paid to perform tasks in campus offices, dining halls, libraries, bookstores. Student employment is also legally distinguishable from professional employment. It's exempt from FICA taxes, for example. As the athletes point out, some work-study students have jobs in athletics, like student ticket takers and seating attendants and food concession workers. Think about it. So athletes are playing in games, and then their classmates, fellow students, some of whom are working at those games, handing out Cokes, collecting tickets. I mean, it's striking to think about it, right? The athletes are playing and not paid, not employees, but their classmates are. It's certainly a point that the plaintiffs have raised, and there's a 4-part economic realities test that weighs whether college athletes perform services for another, necessarily and primarily for the college's benefit. Interscholastics aren't part of any academic curriculum or course, and they're not conducted for academic credit. The plaintiffs say, look, the life and career skills obtained through college sports are often depicted as the kind found in work environments. We know that. Being a student athlete provides all sorts of life training. That's super valuable. That helps people when they get into the professional world. The plaintiffs say that actually cuts against the idea that they're not employees. The athletes also insisted they perform services for the benefit of colleges while under the control of the colleges. The athletes underscore that colleges provide the tools and means like training, equipment, preventative care, in-kind compensation similar to pro teams. The athletes also say they're not independent contractors or volunteers who would have to cover their expenses out of pocket, right? If you've been an independent contractor, you typically pay for things out of pockets. They also can't switch schools for a new gig like an independent contractor could do in certain industries. And some might argue colleges might be better off if some athletes were employees and unionized and then collectively bargain rules. I won't duplicate what's been said, but those rules would then be exempt from antitrust scrutiny, which is the heart of the problem. Even when colleges sign multi-year NIL contracts, some of those players have left, which I think is really striking. In January, Duke University sued quarterback Darian Mensah, who signed an NIL deal through 2026 for breach of contract after he entered the transfer portal to transfer to Miami. So Duke was correct. He clearly signed a contract and it said he wouldn't transfer. But think about the world we're in. Duke University is suing a student, they're still students, over transferring schools. I mean, that's a pretty profound change. I think it kind of signals the world that we're in, that colleges are suing students over transfers. I don't think that's ever happened as far as I know outside of sports. It's not just Duke. University of Cincinnati, they're suing their quarterback who went to Texas Tech. And don't forget about Dartmouth basketball. So I am in New Hampshire, so I'm familiar with Dartmouth basketball. And 2024, that picture that I just showed, I actually took that one because I was at the game the first game where they were unionized employees. I drove up and I bought a ticket and watched the game. December 31, 2024, the players withdrew their petition to the NLRB. So the reason why you don't hear about Dartmouth anymore, Dartmouth basketball, you hear about Dartmouth a lot. It's a fantastic school. They withdrew their petition. But worth remembering, that same year in February, NLRB Regional Director Laura Sachs held that Dartmouth players, the basketball players, were employees within the meaning of the NLRA because the players perform work in exchange for compensation. And compensation, the players argued, is not just payment. It's also preferred admissions into an elite university. It's per diem. It's clothing. It's sneakers. It's access to training and healthcare that aren't available to other students. And the school has the right to control that work. That decision remains citable, persuasive authority. Obviously, it's the players withdrew, and Dartmouth argued. I think Dartmouth believed it would win at the NLRB. Maybe they would have. I don't know. But I'll tell you what, it's not the last of it. And we're going to keep seeing challenges. We're going to keep seeing efforts for employment recognition. Nothing that's done will stop that. I mean, an executive order, even a federal bill, there are a lot of lawyers out there, and several of us know them, that are working really hard to see college athletes recognized as employees and unionizing.
Great. Well, thank you so much, Professor McMahon. And I want to invite Professor Weston back. We've got 5 minutes, and we have questions to respond to. And if you do have any questions that you would like to ask our panelists, feel free to jump in with a question, and I'll be happy to answer it. But first, if you could both address, if you could make one change to the existing legal landscape, what change would you make? And Professor Weston, we can start with you.
One change to the existing legal landscape? Oh, geez. Because it's such a mess right now, but I think addressing the employee question providing some certainty on that would help a lot of things fall into place and decide on whether we can go to a collective bargaining type model that works in professional sports. That might, because now you have so many athletic departments are negotiating with agents from everywhere. They're not certified. They're negotiating with high schoolers, with student athletes. There's no uniformity. So having some uniformity to this process, I think would be an improvement.
Professor McCann?
I think Maureen is 100% right. I mean, the core of this, the instability that we've seen is a function of this peculiar arrangement between college athletes and their schools and conferences in the NCAA. And the chaos isn't going to go away. There will be more antitrust lawsuits, more employment lawsuits, until there is some organized relationship between athletes and their schools that's some form of employment. Now, it could be not all college athletes are employees. Could be some are. It could be maybe those at power conferences. I don't know. I mean, there's different ways of looking at this. But the world we're in now is not going to get stabilized by Congress or by the president, I don't think. And I think several of the panelists would say the same thing. I think at the end of the day, Mark talked about this. The NFL has made a fortune because there is a collective bargaining relationship with the players. We look at these leagues. Without constant litigation, they're able to negotiate contracts, right? Broadcasting deals that are reliable. I mean, the O'Bannon case is a great example. Let's have video games, but don't call them the players' names, but we'll put them in, and then we'll remove the name. I mean, like that's not a good way to do business.
Yeah. So kind of given these changes that you're talking about, Professor McCann, somebody asks if whether there's a necessity now more than ever for an NCAA commissioner with authoritative power similar to what we see in the professional leagues like the NFL, as you were just talking about. Our participant says, I know Nick Saban raised this idea on how to handle NIL, transfer portal issues, parity, employment issues. And Professor Weston, I think this would go to your point about maybe trying to get some standardization. What do you think about that?
I don't think it's the person running the NCAA. I think Charlie Baker is trying, and I think he's trying to be, and I'm from Massachusetts, so I remember when he was governor, he is somebody that tries to be pragmatic. I don't think he's the reason that I mean, this is my personal view. I don't think you have to replace Charlie Baker or have some person above him that somehow is like a super boss to Charlie Baker. I don't think it's that. I think it's more foundational. And I mean, to Baker's credit, he was the one who said some athletes have to be treated differently. And that was a big change from what we heard from previous NCAA presidents. So I don't know. Maybe it's not popular to say he's doing a good job. I think he's trying, and I think he's pragmatic. I think for the reasons we've talked about in this panel, it's much more of a structural issue than putting somebody in place.
Great. And final word, Professor Weston.
Sure. I would agree with that. The NCAA has said, to kill us, you're going to have to invent us. And that's kind of what they're doing with the CSC. Some body has to be in charge of governing, setting what the rules are, having enforcement. And does that make them a cabal, a conspiracy? It depends. So maybe one Marcus suggested, let's have this all go to at the conference level, so you don't have the market power concern with antitrust. But I'm not sure a Roger Goodell would really be an improvement over what's happening now. And I agree, President Baker at the NCAA has brought a fresh perspective to it, and he's trying to work with this process.
I mean, just to that point, would Roger Goodell be any better in this situation? I mean, Goodell can negotiate huge TV contracts because there's a labor relationship. Like, put anyone in that job, and it seems like a no-win.
Great. Well, do we need Roger Goodell in college athletics? It's
Well,
a good.
Being a New Englander, you mentioned Deflategate. I don't know how well that would go over up here, but
Yeah, I'm not a huge. Well, I'm the opposite. I'm not a huge fan of Brady. But anyways, thank you so much. This is a wonderful conversation, very thought-provoking. And I'm going to turn it back over to our host, Dean Len Baynes at the University of Houston. Thanks so much.
Thank you. Thanks.
Thank you. Thank you so much for everyone all in attendance. We had several hundred people on the call. I hope you have learned a lot about a lot of these issues. Many thanks to my Big 12, actually 11 law school dean colleagues who supported this effort to have the CLE on this important topic during March Madness. And many thanks to all our panelists, the general counsel, the law professors, all the folks who are just knowledgeable about all these things. And many thanks to my three dear deaconal colleagues who moderated the panel, Elizabeth Cronk-Warner, Lolita Buckner-Innes, and Stacy Leeds. So that concludes our CLE for today.